All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, March 15th, 2023. We have 7 bills on the docket, and we're going to start off with Senator Carozza with Senate Bill 825. We'll then move to 619, 566, 683, 653, 761, and then we'll end up with Senator Benson with Senate Bill 771. So without further delay, Senator Carozza, you're up. Welcome.
Thank you, Mr. Chair, and thank you to the members of the Senate Judicial Proceedings Committee. For the record, Senator Mary Beth Carozza representing Worcester, Wycomico, and Somerset counties. And I am here to present Senate Bill 825, handgun permits, expiration and renewal periods for retired law enforcement officers. I also want to thank and appreciate the co-sponsorships of my colleagues, Senators Jackson, Bailey, and Foden, for co-sponsoring this legislation as both former and current law enforcement officers. This legislation, Mr. Chair and members, would simply extend the expiration and renewal periods of handgun carry permits for law enforcement officers who retired in good standing. Currently, permits are valid for a 2-year period after the initial issue date and are valid for 3-year periods thereafter. Under this legislation, permits for retired officers, again in good standing, would be valid for 7 years after the initial issue date and would be renewed every 5 years thereafter. This is a narrowly focused bill that simply improves the process for handgun renewal for retired law enforcement officers, and it recognizes their years of service, good standing, and training. We want to keep our retired law enforcement here in Maryland, and as someone who represents many with Ocean Pines bordering Delaware and Virginia and other choices, again, we want to keep our retired law enforcement here in Maryland. And this is just a simple and straightforward way to support our retired law enforcement. I truly appreciate your kind attention and consideration, and I respectfully ask for a swift and favorable report to Senate Bill 825. And if it would be okay to hear from Mr. Rick Norman from the Maryland Troopers Association before taking questions.
Good afternoon, Senator. Chairman. Sir, if you could, Mr. Stand up at the podium, please. Sure. Thank you. And then we do have, is Mr. Ficus here? Dan Ficus, come on up.
Good afternoon, Chairman Smith and Vice Chair Wallstriker, members of the Judicial Proceedings. My name is Rick Norman. I'm a retired captain from the Maryland State Police, serving the citizens of the state of Maryland for over 28 years. I'm currently the executive director of the Maryland Troopers Association, representing over 2,600 active and retired troopers. Almost 1,500 are retired state troopers. The Maryland Troopers Association supports the proposal to create alternative expirations and renewal periods for the handgun permit issued for the retired enforcement officers. When we retire in order to get a handgun permit, we have to retire in good standing. We have to apply for a permit. It's not automatic. And we have to, our letter of good standing is placed in the file. We go through a background check like everyone else. As state troopers, even in retirement, we continue to service the people of the state of Maryland. I myself know that a friend of mine I went to the academy with a couple of years ago actually came upon an accident and pulled 2 people out of a car that started on fire and then saved their lives. And he's been retired as long as I have, since 2005. This legislation has the potential to create a simpler process for handgun renewals for retired troopers. Our retired police are in good standing and appreciate the trust of Marylanders and consider this renewal process appropriate. There's an incident just happened, if you all know, that Sergeant Phillips was just shot on the Eastern Shore 3 times. His bulletproof vest saved his life. 2 of the suspects were at large. A retired trooper that we got information was who's building a home, got word that the suspects may have been in the neighborhood, went to the house that he was building and actually found them inside and held them at gunpoint. He has a handgun permit issued by the Maryland State Police, called 911, had the police. So there are incidences where we as retired officers do get involved with the community and get with service, and it's good for us to have this. We hope that the committee sees the benefit of this and can have the members of the Maryland State Police and retired members of the Maryland Troopers Association get this benefit. Thank you for your time and consideration. We request a favorable report for Senate Bill 825, and I'll be happy to answer any questions if you have any. Oh, I'm sorry.
Good afternoon, Chairman, committee members. My name is Daniel Fickus. I'm a 35-year retired veteran of the Baltimore Police Department. I'm also a past president of the Baltimore City FOP and a member of the Maryland State FOP. The Maryland State FOP represents over 20,000 officers, of which over 6,000 of them are retired. Both the active and retired members of the Maryland State FOP fully support HB 825. HB 825 is a common sense legislation in that extending the renewal cycle for retired law enforcement officers from 3 to 5 years not only represents a reduction in transactional time, but also administrative processing. Fiscally, other than the initial projected computer programming expense of approximately $150,000, future costs are estimated at zero expense. That is cost zero. Under current law, retired law enforcement officers who retire in good standing from their agencies, application and renewal fees are waived for the Maryland handgun permit. On a sidebar, a majority of our states have a 5 or year more renewal period. On behalf of the Maryland State FOP, we fully hope that you support HB 825. Thank you.
All right, thank you all very much. Questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator Carozza. Thank you. All right, so that'll conclude the testimony in the hearing for Senate Bill 825. We'll now move on. I see Senator Heddleman is here with Senate Bill 619.
Thank you very much, Mr. Chairman. I'd ask my panel to come up, and I apologize that I am going to have to leave. I'm going to have to give my testimony and go vote on the budget because my subcommittee is meeting and voting right now. Hopefully I may be back. My name is Shelley Heddleman. I'm the senator from District 11, and I promise this is the last time you are going to see me this session for a bill hearing. I am here today to present Senate Bill 619, and I have fabulous panelists here who are going to be able to answer any questions you may have. This is a bill about strategic lawsuit against public participation. It is called SLAP. It is something that some of the committee members are familiar with and some are not, but I think this is a bill about protecting the little guy. It's about protecting any one of us from a SLAP, which is a meritless lawsuit filed by somebody who has deep pockets, meant to slap us down, to intimidate us, and to make us willing to forego our First Amendment rights and drop our lawsuit because we can't match the plaintiff's extraordinary resources. The First Amendment is fundamental to our democracy, and that was reflected in our action when Maryland was one of the first states in the country to enact a SLAP statute. It is vital to our democracy to protect our ability, or our homeowners association's ability, or our newspaper's ability to speak on matters of public concern, to share with our local county councils or the public what we think about a development project, for example. It is vital that our constituents have the ability to participate in the public marketplace without being threatened by a meritless lawsuit by a developer or an individual who has the resources to intimidate and quash our free speech. That was the aim of our forebears, the legislators who enacted our original SLAP law. But our law is flawed, we have learned, and it has earned a D by the Public Participation Project because of its insufficiency. This bill strengthens our law. The purpose of Maryland's anti-SLAP law is to enable a judge to dismiss such suits early in the litigation process, doing away with the burden of lengthy and costly litigation and to preserve a defendant's right to free speech. The bill does 3 important things. The bill will eliminate the bad faith requirement from a SLAP suit. This requirement places an undue burden on the vulnerable defendant and provides an unnecessary protection for the plaintiff, contrary to the purpose of the law. The bad faith requirement not only asks defendants to show that the suit brought against them is meritless, but that it rises to the level of bad faith. Second, the bill shifts attorney's fees, which creates a deterrent to a deep-pocketed plaintiff. And finally, it requires courts to act promptly and to hold discovery until there are expeditious rulings. And one last thing, This bill is agnostic with regard to politics and perspective. SLAPP suits have been filed from the right and from the left. And as you will hear, strong SLAPP statutes serve to protect all who have been wronged in this arena, protecting the First Amendment without regard to politics. I would ask for a favorable report on Senate Bill 619. And with that, I will turn it over to the experts on my panel. Thank you very much.
Oh. Thank you. Got it. Thank you, committee and Chair Smith. My name is Rebecca Snyder. I'm the Executive Director of the Maryland, Delaware, DC Press Association. And I wanted to share with you the press's perspective on this, but also recognize, as Senator Hedelman said, that this is a much broader issue and our panelists will address their personal experiences with this. So we are pleased to support Senate Bill 619. It has, this is a bill that has been heard in committee in the same posture last year and the year before. It has also passed the House. It has already passed the House this year and passed in the same posture last year and the year before. Maryland's anti-SLAPP statute is at risk of falling into disuse and irrelevant unless it's reformed. We really want to make sure that Maryland has a functioning anti-SLAPP statute. The three pieces of the bad faith requirement, the shifting of fees, and the clarity of process is critical. For news media, it means, and you'll see this in my written testimony, you'll see that suits have been brought against news media in a frivolous way over reporting that has been substantiated and verified, and the plaintiff just wants to stop news media from reporting. It takes a toll because every member who has to defend against a SLAPP suit, and you all know how expensive it can be to defend, means that those resources are not being put into reporting resources that serve the community. And it also puts a chilling effect on the public process. So you can hear incidences at the Frederick News Post, the Carroll County Times, individual publishers. We believe this is a balanced bill that will help the little guy speak out on matters of public interest, and it will protect news media. So we ask for a favorable report. I'd like to turn it over to Max Michigan next. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Max Michigan. I'm an attorney in the Media and Entertainment Law Group at Ballard Spahr, and I appreciate the opportunity to speak today in support of Senate Bill 619. I'd like to touch on just a few points from my written testimony about how this bill would improve the Maryland anti-SLAPP law and why that's such an important step for our state. First, the changes that Senate Bill 619 would provide have a proven track record. You can look at anti-SLAPP bills across the country, and you'll see state after state agreeing that when someone sues over speech on a matter of public interest, the person suing should have to show early on that the case has merit. Likewise, you'll see consensus that when a plaintiff brings a meritless SLAPP lawsuit and loses, the plaintiff should have to pay the defendant's attorney's fees. These are the kinds of provisions that make an anti-SLAPP law effective and reliable. Second, a stronger anti-SLAPP law helps organizations of all kinds and people of every political leaning. I've seen that firsthand as my colleagues at Ballard Spahr and I have filed anti-SLAPP motions for a pair of conservative anti-abortion filmmakers being sued by a Democratic state court judge, and for a national Democratic advocacy group in a lawsuit brought by a GOP megadonor. So I just want to pause on that point for a moment, because I understand that opponents of the bill claim that a stronger anti-SLAPP law would suppress the speech of pro-life activists and organizations, but the truth is that anti-SLAPP laws protect pro-life and pro-choice speakers equally against meritless libel claims aimed at silencing them. In just the past few years, we've asserted anti-SLAPP provisions against an iconic Republican sheriff and against a rising star Democratic lieutenant governor. Anti-SLAPP laws are not a partisan issue. Third, now is the time to put these protections in place. Libel bullies bring libel lawsuits every day because they feel confident that even if they lose the case, they can still win the fight. They can make defendants spend time and money and think twice before expressing themselves again. Senate Bill 619 is the right bill to take on this growing threat to free speech. I encourage you to report it favorably. Thank you for the opportunity to testify today.
Good afternoon. I am Stephanie Flash, a mother of two boys, a caregiver for my disabled mom, and an Army spouse. I have lived in Harford County since 1995 and am an active community volunteer. And I'm a prior Army officer, a military officer. So being named as a defendant in a SLAPP lawsuit was an overwhelming and frightening experience. I remember receiving a phone call from a local paper asking how I felt about being named as a defendant in a lawsuit because of a community petition that I had helped create. I was at a loss for words. And then when I was served with legal documents, I became very panicked. Confused and shocked, I tried to understand the reasons behind the lawsuit. Why would a petition that never identified the plaintiff or any business turn into a civil case? Being accused of falsifying names on a petition, charged with acting with disregard for truth, and faced with a claim of a judgment over $75,000 was terrifying. I was overwhelmed with the reality of a deep pocket developer would shut down our public participation, and I had no protections against the frivolous lawsuit without paying a fortune. My husband and family were stressed about the financial burden, and my kids, 15 and 11 at the time, were living in a household with constant duress. Friends were shocked and upset about this lawsuit, but they shied away from public support due to the fear that the developer might retaliate against them as well in a lawsuit. This lawsuit discouraged the community from participating in the county process because of the mindset of the deep-pocketed developer will always triumph. I was angry when hearing the community's attitude and felt really stupid for even getting involved in the first place and putting my family at risk. I have experienced firsthand the burden of the SLAPP lawsuit, and I fully support Senate Bill 619. Please help protect Marylanders from the SLAPP nightmare and protect those who dare to speak up.
Good afternoon. My name is Beth Pajoli. I'm from Harford County, and I thank you for the opportunity to speak today. I remember that day in 2016 very well. It was a week after meeting with the Harford County executive about his proposal to expand the public water and sewer in our rural community. There was a hard knock at the door. A stranger was standing on my front porch pounding. I was terrified. He left that day and returned a few days later to serve notice of a lawsuit in the amount of $75,000 against me for creating a petition against public water and sewer expansion in Harford County. Within days, news of the lawsuit reached the local paper. Stephanie Flash and I were splashed across the front page. People questioned what we had done. I felt ashamed and ignorant for trying to participate in a public process. Quickly, people in our community became quiet as rumors of lawsuits clouded the issues. I felt a range of emotions during this time, and I was angry that a stranger could use the legal system to discourage us and most of our community from participating. I had no idea this type of thing could happen, and I quickly discovered that many states have acted by passing stronger anti-SLAPP legislation. I believe this bill, SB 619, would dissuade those with deep pockets from using this tactic. During that horrific time, we felt it critical, Stephanie and I, to hire a lawyer and incurred a large legal bill. I have a home and 4 children, and $75,000 is a lot of money I don't have. Due to Maryland's weak anti-SLAPP laws, we were unable to successfully countersue for legal fees and were left with a legal bill of $8,000. I was impacted financially, emotionally, and mentally for months as the threat of lawsuit dragged over the summer. I believe this type of lawsuit, aka SLAPP, is inherently wrong, unjust, and seeks to use the judicial system as a means of legal extortion. I fully support stronger anti-SLAPP legislation in Maryland, starting with SB 619. Thank you for the opportunity to speak today.
All right, thank you all very much. Questions from the committee? All right, seeing none, thank you all. Thank you for your testimony. Thank you for being here today. Have we heard from John Breen?
Right here, thank you.
There you go.
Mr. Chairman and members of the committee, I'll be brief. Thank you for allowing me to speak here. When I registered for this testimony, I sent you my testimony for a bill I testified about last year, ignored it. The MHA has also filed their own opinion. That's what I meant to file when I filed my opportunity to testify. I want to focus on the crux of this. The purpose of this bill, SLAP, is to allow a defendant of a SLAP suit to file a motion to dismiss, to challenge the meritorious nature or the lack of meritorious claims of that before he incurs large amounts of money or cost and attorney's fees. And if the court so finds after hearing after 30 days of some kind of quick testimony, he may award costs and attorney fees of the matter. There's a flip side of this. If the court finds that, and I can't imagine a fact pattern when this would occur, that the defendant is the one who's filed the lack of meritorious claim by saying that he's being bringing a false claim by asking for the motion dismissed, the court has the power to exercise the same judgment. So there's a balance here, which keeps, in my view, it protects the integrity of Senate Bill 619 and gives us a reason to give further support to it. If there are no questions, I just wanted to raise that one issue.
All right, thank you, Mr. Breen. Questions from the committee?
Thank you very much.
Thank you all very much. All right, thank you. All right, so with that, that'll conclude the in-person testimony for the proponents. We'll now switch to the in-person testimony for the opponents, and we'll hear from Nicole Hollywood. Is Laura Bogley here?
I'm here for the next bill.
Okay, got it. I've got you here for 619 for some reason, but hey, stick around. We'll put you. We'll make sure you're next time. Yep, you're up.
Madam Senator, thank you so much, Senator Smith. Members of the committee, thank you for the opportunity to speak with you today. I'm Laura Bogley, Executive Director of Maryland Right to Life. And on behalf of our members across the state, I strongly oppose this bill once again and respectfully urge you to preserve free speech and the integrity of the Assembly and the courts by rejecting this bill and its broad expansion of frivolous lawsuits. You've heard from a lot of proponents today, and unfortunately, I think many of them are here with a good intention to prevent citizens from being harassed with frivolous lawsuits. Unfortunately, this bill is not an anti-SLAP bill. This bill is a pro-SLAP bill. This bill creates a huge legal loophole for people with money and influence to deny citizens, to deny the little guy, the affirmative defense that a suit brought against them was a frivolous lawsuit. The bill's bad public policy, and that is why the Assembly has seen fit to reject it year over year. The bill asks you to abandon the longstanding principle to undermine your original legislative intent to discourage frivolous lawsuits, and instead authorize this huge legal loophole for mega media corporations and others to file endless frivolous lawsuits to intimidate their opponents and chill free speech. The new controlling doctrine would be free speech for me, but not for thee. Why should mega media corporations have more rights than the average citizen? They should not. The original statute is neutral on its face and ensures that the courts remain neutral arbiters of the law. But this bill asks you to weaponize the courts against individuals and otherwise protected speech by engaging in content discrimination. By enacting this loophole, the Assembly would be denying Maryland citizens equal protection under the law and reducing the courts to mere political thought police. As we experience a legal and cultural shift on the issue of abortion, pro-life citizens and organizations have been under increasing threats of violence and prosecution, and SLAP suits are one of the methods that they have used to try to suppress pro-life speech. For these reasons, we strongly oppose this bill and respectfully urge your unfavorable report once again. Thank you.
All right, questions from the committee? Senator Sidnor.
Thank you very much. Your testimony is that these suits have been used to limit the speech of pro-life advocates. Could you give me an example?
Absolutely, Senator Sidnor. There was one right here in Baltimore City where the city tried to pass an ordinance to restrict the free speech of a pro-life pregnancy center as commercial speech. And they claimed that they were falsely advertising. And the court in Maryland, the Maryland Court of Appeals, held that invalid. That was a frivolous lawsuit used to try to put the pro-life pregnancy center out of business. So the court found in favor of the pro-life pregnancy center.
Thank you.
Thank you.
Further questions? All right, seeing none, thank you very much.
Thank you, Senator.
All right, we'll now switch over to our virtual participants. We're going to go with the proponent first. Is Paul Levy in the room?
I'm here.
All right. You're up.
I
Welcome.
don't seem to be on. Oh, I see. My camera's off there. Okay, there we go.
There you go.
So I've spoken to the committee before about why consumers like this bill. And there's a lot of that in my written testimony, but I want to address instead some of the arguments made by the opponents. First of all, Mrs. Barber, I've studied the lawsuit that Mrs. Barber filed. She was accused by a lawyer of running in a partisan election for a nonpartisan position. And that complaint was actually truthful because she had to run in partisan primaries, in the Republican primary and the Democratic primary, which were partisan elections. So the complaint against her was truthful and would not have succeeded. And in fact, she was fired from her position as an administrative law judge for that very reason. Indeed, she later sued that lawyer in state court, but she chose not to sue in Maryland, which had no effective anti-SLAPP law. Instead, she chose to sue in the District of Columbia courts, which did have an effective anti-SLAPP law, and she survived an anti-SLAPP motion. She put in an affidavit asserting that the statements made about her were false, and then she secured a $100,000 settlement because the insurance company decided not to defend the case. So I think it is not correct that an effective anti-SLAPP law would have prevented her from succeeding. This law would be slightly weaker than the DC anti-SLAPP law and would not have prevented her from going forward. Now, I've dealt to some extent in my written testimony with this contention that conservatives are disfavored by anti-SLAPP laws. Jim Bopp, the general counsel of the National Right to Life Committee, is a strong supporter of anti-SLAPP laws because anti-SLAPP laws have been used effectively time and time again to protect anti-abortion or pro-abortion speakers or anti-abortion speakers. I can supply much more information in further written materials or answer questions if the committee has any.
I appreciate it, Mr. Levy. Since you're the last proponent testifying virtually, we'll open up for questions. Seeing none, thank you very much, Mr. Levy. Ms. Barber, you're up.
Good afternoon, everyone. The strategic lawsuits against public participation looks very meaningful on its face. However, it may have grave consequences against public figures by arming citizens with the right to report anything and everything to public entities and rewarding those citizens with ulterior motives who do the reporting with blanket immunity and attorney's fees. Not even civil rights litigants enjoy this special attention to resolve the case quickly by making a special motion. We saw on January 6, 2021, how people engaged in conspiracy theories wrongly claimed First Amendment protection for their insurrectionist acts of terror. The First Amendment should never again be used as a reason to harm individuals or destroy human beings. One of the pitfalls of this legislation is that it does not protect innocent victims such as public figures or politicians who may have rivals instigating stories by using public records, resources, and government agencies to create news stories to smear an opponent. It particularly impacts people of color and their communities when misinformation is spread to newspapers to criminalize them and destroy individuals' livelihood and reputation. In 2016, an ex-judge, not just a lawyer, an ex-judge, filed an ethics complaint against me, asking my employer to remove me from office because I ran in a partisan primary. Now, what Mr. Levi did not tell is the truth. The truth is that the office of circuit court judge is not a partisan office. They do not run as Democrat judges or Republican judges. That is not true. So all of the statements he made about the statements of this ex-judge who filed this complaint were true is not true. They were false. What the complainant did not do is tell my employer that the office of judge, again, was not a partisan office. So I urge again that the Senate Judicial Proceedings Committee issue an unfavorable report on this legislation. Thank you.
Excellent. Thank you very much, Ms. Barber. Questions from the committee? Well, I'm sure glad you and Mr. Levy both testified virtually today. That would have been really weird if you're both here. All right. A little funny. All right. All right. With that, that'll end the testimony for Senate Bill 619. We'll now move on to Senate Bill 566. Senator Reedy, you're up. Welcome.
Chairman, can I bring up folks that are here with me? I think I have 4 folks here, maybe 3. They'll come on up. It's nice to see you all. Yes, I do miss this committee. Sometimes. Not at 7:30 or 8 o'clock sometimes, but. Yeah. Well, it's good to see you all today. And I know we've been spending a lot of time together on the Senate floor, and then we're all back into committee. And I just think it's important. I know that you've heard a lot of different issues today, and this is one that I think I really hope you're able to hear kind of with fresh ears about this issue. Senate Bill 566, Mr. Chairman and Vice Chairman and members of the committee would establish that a parent has a fundamental right to direct the upbringing, education, care, and welfare of the parent's child. The state would be prohibited from infringing on a parent's fundamental right to do so. And in the bill, of course, it provides for circumstances where the state would be able to do that, but obviously have to show that they had a compelling reason to do so. This would codify in our state law what's been ruled by the Supreme Court. It's 1997, Washington versus Glucksberg. The Constitution, and specifically the Due Process Clause of the 14th Amendment, protect the fundamental right of parents to direct the care, upbringing, and education of their children. And there are ways that I think there was even a discussion on the floor we had recently about where a parental right is, and it's in common law, of course, and the Supreme Court, as I've just mentioned, has ruled it. But as we've been talking about constitutional rights and fundamental rights in our body this year, having it listed in the state law provides for strict scrutiny protections. And so that's why it's important to have this legislation and have it codified in state law. There's been for a lot of folks around Maryland and around our country, there's been a disturbing trend in public policy as it relates to children and their parents. There are times that in our policy, there's a bit of, I think I call it an implicit bias amongst some policymakers and certainly some in government roles, that sometimes parents can almost be treated as if they're an obstacle to their children's success, or that they have something that has to be managed around. A parent has to be sort of managed around. When parents object to things in a school situation, to a school board, our federal government had called. There was correspondence that tried to identify parents that protested at school boards as terrorist threats. There are surveys given to middle school children that talk about subjects that were probably unimaginable for a 6th grader to be talking about with other adults 20 to 30 years ago, and parents have concerns about that. But there's at times, and we've even passed legislation in the General Assembly to weaken the ability of a parent to know when their child is consenting to mental health counseling if they're over the age of 12. And I'm not here to relitigate those fights. I think the reason that having something very clear in our state law that establishes fundamental parental rights is really important, because these are conversations we're going to continue to have. Again, our goal here is to put this in state statute to codify Supreme Court rulings. What Senate Bill 566 does not do, it does not give parents authority to overturn, to go and dictate exactly what curriculums are used in schools. It does not give them the authority to override broad law as it relates to different sorts of standards in health. But what it does do is say very clearly that a parent, the default of the state is that a parent has the right to direct their child's education, health, and upbringing. And I'll tell you one other thing that's concerned me. And now that I'm on the Finance Committee, we do a lot more. We obviously do a lot in the healthcare policy arena, as all of you in this body, in this committee know. And there's even lots of attempts at times to try to get the pediatrician and the parent out of the equation on certain things. We've even had legislation this year has been withdrawn about vaccinations and letting the children consent to vaccinations at a younger and younger age without even necessarily a prescription, certainly without a parent's knowledge. So, and those aren't really moving forward. But again, think it's just really important, no matter what side of any political aisle you're on, that we establish that fundamental right, and that's where we start. I do have an amendment that we have drafted that came up in the House hearing to make sure that the judiciary wanted to just be sure that the language didn't conflict, obviously, with the court's ability in cases where in divorce situations and other things to adjudicate best needs of the child. So that's an amendment that's also here or should be here. And if you don't have it, I'll be sure you have it. But I would just ask for your support on this to do this. This is really something putting in state law, and it protects people of all persuasions, just to be sure they know that it starts with a parent's right to dictate their child's upbringing, health, and education. So with that, Mr. President, Mr. Chairman, don't want to tell the Senate President, Mr. Chairman, I'd be happy to take questions, or we can listen to the panel. That's fine. And who would like to go first? You want to go first? You come up. Do you want them at the podium?
Let's see, hello? Okay, just making sure you could hear. Hello, my name is Kit Hart. I am the mother of 5, and I serve as the chair for the Carroll County chapter of Moms for Liberty. I'm asking that you submit a favorable report for the fundamental rights protected in SB 566. As legislators, you have positions of honor and trust. But for those of you with children, I am confident that you consider your role as parent to be paramount. I'd ask you to consider which beliefs, values, or virtues you've instilled in your children. Maybe they are religious dogmas. Maybe they are your worldviews and strongly held convictions. Now imagine if another adult told your child that those views were wrong. Consider how you would feel if a government institution required you to do something to your child that you knew to be harmful. That is exactly what happened to thousands of parents here in Maryland due to the government's response to COVID. Each day, when my preschooler came out of school with a mask drenched in saliva, my rights as a parent were violated. When my first grader's stutter stunted his learning because he couldn't mimic words as he learned to read, my rights as a parent were violated. When my 3rd grader with ADHD couldn't focus due to the filthy plexiglass partition surrounding his desk, or couldn't expend energy with his running around with his friends, my rights as a parent were violated. And when I couldn't take my toddler to the playground because it was ghoulishly plastered in tape, my rights as a parent were violated. Still, I consider myself one of the lucky ones because I had the support and ability to bring them home to educate them myself. Many parents feel that they no longer have a choice and are willing to do whatever it takes to defend their rights as parents. Perhaps that's why Maryland has seen a 10% increase in homeschooling since the pandemic, and we continue to watch that number rise. Parents feel that the partnership between the family and the school system has been eroded. We need this bill in order to give parents a seat back at the table. While we may not all agree on parenting styles, family values, or political viewpoints, we should all agree on one notion, that the parent-child relationship should never be severed. I'd like to thank Senator Reedy for sponsoring this bill and ask that you'd please join him in upholding and enshrining the fundamental rights of parents by submitting a favorable report for SB 566. Thank you.
Mr. Chair and committee members, good afternoon. I'm Jonathan Alexander, an attorney and counsel for the Maryland Family Institute, and we support Senate Bill 566 and the proposal that it puts forward to empower, encourage, and embolden parenting in our state. You know, this committee has a wonderful opportunity, as many bills are otherwise restrictive or constraining. This proposed law is freeing. It's an encouragement to one of the most sustainable institutions that any society knows, which is parenthood. I'm from Charles County, and on our street, every home is a 2-parent household, a mother and a father. And that makes an immediate difference in any place that family structure is prevalent. There's a 50% jump out of poverty from single-parent households to married mother and father households. There's a 60% swing from individuals relying on government food stamps from single parent to 2 married parents. And there's a 25% difference from the percentage of children who experience violence based on 1 parent versus 2-parent households. Children in married family married couple families are less likely to drop out of school, and they're more likely to seek healthy relationships which mirror how they were raised. And that all statistically happens when parents are empowered. You get less crime, less poverty, less reliance on government services. And that is sustainable for Maryland and what we should encourage. Now, when those parents are at the helm of decision-making for their child, it also works well. There are tangible results that are measurable. So parents in this state should therefore be given the recognition and the respect in law to direct the upbringing of their child without unreasonable state interference. It's a right that's been recognized by the Supreme Court. It's deeply embedded in the foundations of our nation. It's the culture that this committee now gets the opportunity to make here in Maryland. And for these reasons, I urge you to support Senate Bill 566.
Good afternoon, Mr. Chairman, members of the committee. My name is Kevin Connors. I'm a father of four. I too am in favor of SB 566. And I'd like to begin by quoting from a column recently authored by the Secretary of Education in the Biden administration, Miguel Cardona. This was published at Newsweek on March 1st of this year under the title, "We are raising the bar for parent partnerships in our schools." And I thought the following excerpt was very interesting. He says, quote, "We are dedicated to enforcing federal laws that protect students and parents' rights. Current federal law enshrines these rights, including requirements that parents receive information on how their children are performing academically, and that parents can inspect the school's instructional materials. Under our watch, the Education Department is committed to vigorously enforcing these protections." End quote. Now, when I read those words, I had two thoughts that came immediately to mind. The first being, it's wonderful to see the Secretary of Education in the Biden administration coming out and getting on the record that parental rights are important and that they should be enforced vigorously. My second was that as a layman looking at SB 566, it strikes me that what we're doing here is really little more than harmonizing the laws of Maryland with those at the federal level. And in doing so, I think it sends a very welcome message to parents in Maryland that their representatives believe that parental rights are important and should be vigorously enforced. So if I'm right on both of those, it seems like this sort of legislation should be non-controversial, if you will, and it would be wonderful to see it move forward on a bipartisan basis. Thank you all very much.
Chair Smith, Vice Chair Waldstreicher, members of the committee. My name is Will Estrada. I'm the president of the Parental Rights Foundation. I'm a dad of two, and I'm proud to be here and speaking in support of SB 566. It's a common sense bill that is premised on 100 years of U.S. Supreme Court precedent that parental rights are a fundamental right. You know these cases: 1923, Meyer versus Nebraska; 1925, Pierce versus Society of Sisters; 1972, Wisconsin versus Yoder; as recently as 2000, Troxel versus Granville. Maryland's highest court, the Court of Appeals, has also recognized that parental rights are a fundamental right. For example, in McDermott versus Doherty in 2005, the highest court here in Maryland said, "Our courts have left little doubt of the importance placed on the parent-child relationship. As this court recently stated, the Supreme Court has long recognized the right of a parent to raise his or her children as a fundamental one, protected by the Due Process Clause of the 14th Amendment." 15 states already have laws like this one protecting parental rights as a fundamental right. Those are West Virginia, Kansas, Michigan, Texas, Utah, Colorado, Arizona, Nevada, Virginia, Oklahoma, Idaho, Wyoming, Florida, Montana, and Georgia. These are blue states. These are red states. Some of these laws have been on the books for 30 plus years, and they show that parental rights should be protected. If this bill is enacted into law, it will provide strong common sense protections to parents and children in the state of Maryland. You as the legislature are charged with protecting the rights of the people, so this belongs in the Code of Maryland, not just in court precedent, which, as we all know, can change. SB 566 is a common sense bill that protects the fundamental constitutional rights of all parents in Maryland, rich and poor, black and white, urban and rural, Republican, Democrat, gay, straight. I respectfully urge that this bill be passed into law in the state of Maryland. Thank you so much.
Thank you very much, Mr. Estrada. Questions from the committee for the first panel? All right, seeing none, thank you all very much. Thank you, Senator Reedy. Is Valerie Walters here and James Thomas? And then if we have Susie Scott.
Good afternoon. One day after school in the fall of 2021, our youngest son came home and told me that he wasted an hour taking a dumb survey that asked all kinds of inappropriate questions. I asked for examples, and what followed absolutely baffled my mind. Which of the following best describes you? Heterosexual, gay, lesbian, bisexual? I'm not sure. Some people describe themselves as transgender when their sex at birth does not match the way they think or feel. Are you transgender? Some people describe, has an adult or person at least 5 years older than you ever made you do sexual things that you did not want to do? Count such things as kissing, touching, or being made to have sexual intercourse. Have you ever had sexual intercourse? How old were you when you first had sexual intercourse? The last time you had sexual intercourse, did you or your partner use a condom? The last time you had sexual intercourse with an opposite sex partner, what one method did your partner use to prevent pregnancy? During your life, how many people have you had sexual intercourse with? Did you drink alcohol or use drugs before having sexual intercourse the last time? Mind you, this survey's very first question is to choose your age between that of 12 and 18 years or older. My daughter confirmed she took the same survey as everyone else in that school during second period that day. I then attended a board meeting that night. I asked administrators what survey this was that my children took. They had no idea. They looked at me like I had 10 heads. After much research during this meeting and calling around, it was discovered to be the Maryland Youth Risk Survey and Tobacco Survey. They had no idea that these were the questions asked. I asked why no adult had knowledge of the material presented to students in their custody. They all said they had never even looked at it, let alone taken it. It was administered by the Department of Health, was their excuse. Then it was brought to my attention that I could opt them out the following year. So I did. But guess what? Both of my children were given that survey again against our permission, and there is no recourse for the Maryland State Department of Education. My name is Valerie Walters, and I'm here asking you to vote favorable for the Parental Bill of Rights. I'm here not just on behalf of myself, but many other parents far and wide that have similar values and issues within our public school education system. Again, I am requesting you to please vote favorable.
Good afternoon. My name is Jim Thomas. I live in Baltimore County, and I'm the proud dad of 3 kids aged 10, 8, and 3. Today, I speak in support of SB 566, which affirms parents' fundamental right to direct the upbringing of their children. It seems odd that we might need a law to underscore or protect what, in years past, no one would have thought to question. Today, at a time when well-meaning school educators and administrators are caught in a cultural crossfire, all of us, parents and teachers alike, may need a legal framework that affirms and ratifies this very basic, even sacred, understanding that a child's parents must be involved in any aspect of their child's upbringing, and that no adult outside of that sacred covenant may independently intervene. Surely a healthy society and a robust democracy demand that adults acting in good faith meet in disagreement over any and all viewpoints. And it is certainly true that children exist in community with adults and other children who will expose them to all manner of ideas. This is only as it should be. But the root and anchor of any young mind and heart is the home and their parents. These are contentious times. There will always be contentious times. Surely, if we lose the bedrock of home and family, we risk all. Please support SB 566.
Thank you, Chairman, Vice Chair, and the members of the committee for giving me a seat at the table today. My name is Susie Scott. I'm a mother of 5, grandmother of 3, one on the way, and I'm the chapter chair of Moms for Liberty in Harford County. I'm here today to request a favorable report for Senate Bill 566. Parents all over Maryland and even around the country are requesting legislation to recognize their fundamental parental rights so that they too can have a seat at the table when it comes to decisions affecting their children's upbringing, education, and medical care. For far too long, the teachers' unions and other powerful special interests have held sway. They have heavily influenced policy and curriculum. As those with substantial power often do, they go too far and overreach. Parents have seen this happening in some of the legislation that is being proposed in this General Assembly. A case in point would be the controversial House Bill 119 cross-filed with Senate Bill 199. When parents came to testify against House Bill 119, we were met by those powerful special interests that are used to having their way here in the General Assembly. Many of these groups testified for a favorable report with amendment, and the amendment they requested was that no opt-out option be provided for parents who objected to the controversial health curriculum frameworks. You see, these special interests think they know better than parents. Out of an abundance of hubris, these powerful lobbies demand parents defer to their expertise. Senators, parents are the experts when it comes to their children. By giving a favorable report to Senate Bill 566, you can put an end to the overreach and stop the infringement of parents' fundamental rights to direct the upbringing, education, care, and welfare of their children. Will you stand with parents by establishing our fundamental rights as contained in Senate Bill 566? I urge you, please give a favorable report to Senate Bill 566 and give the parents of Maryland a seat at the table. Thank you.
All right. Thank you all very much. We have a question from Senator Sidnor.
So, all right, on page 2, lines 6 and 7, it says a parent has the fundamental right to direct the upbringing, education, care, and welfare of the parent's child. My question is, I would assume, and we all know that we're all different parents and we all will have a different way that we want to direct the upbringing, education, care, and welfare of our children. So how do you square that when you have opposition and how you may want to bring your child up and how I may want to raise or rear my child? Witness who last spoke. And if you don't.
So yes, you as a parent are going to see things and raise your child in the viewpoint that you have, and other parents might have things in a different viewpoint. But there's legislation being presented that is just one way. Our children are going to learn this health curriculum and this curriculum, and there's no opt-out provision under House Bill 119 if a parent objects to certain ideologies being taught to their children. So my rights as a parent are being infringed if I can't opt out my child out of something that goes against my belief system, against my religion.
So you're asking for an opt-out or for some other piece of legislation, not necessarily a declaration that a parent has a fundamental right to direct the upbringing, education, care, and welfare of the parent's child.
What I'm saying is when there's only one curriculum and there's things that in that curriculum that are objectionable, and it's currently when there's a health lesson is being presented in school, parents get informed, so they're supposed to get papers and permission slips, and they're supposed to be able to view the curriculum. But now we want to have this curriculum that's being fundamentally changed to include gender ideology at kindergarten and grade 3, which some parents find objectionable. There's other lessons in middle school that parents find objectionable. And so they're not able to opt out. Their children have to be subjected to this. And so we're saying our rights as parents are being infringed.
in this way. In other bills, there's legislation like Senator Reed talked about, where they're lowering the age of consent for vaccinations, and parents don't have any say, about that. If their child is in school and they're being offered a vaccination and they're a certain age and they consent to it, the bills are saying, okay, you can, I consent because you're going to give me a pizza party if I take this vaccine. And parents are saying, wait a minute, we want to be informed on our children's medical situation. So there's more and more bills that are coming through this assembly that are stepping on parents' rights. And so we want parents' rights to be upheld.
Senator Reedy, this piece of legislation is being put into the family law section. Is this, and I'm listening to your witness, and this goes beyond sex education and the like, correct?
Well, to be honest with you, this is really not necessarily, the bill itself is not about the curriculum specifically. I think we're using this curriculum situation as an example of what happens when there's an attitude that doesn't embrace that parents have the fundamental right to direct their children's upbringing and education. And it is true, it's been mentioned, in that specific example, people pushing to get rid of even an opt-out of something. This, though, is just trying to codify what the Supreme Court has said, which is that parents have a fundamental right to direct the upbringing of their children, and that should be the default of where the state starts. Obviously, there are ways the state, any state, no matter how strong their statute would say there's fundamental rights, could intervene.
So here in the state of Maryland, the state has a constitutional obligation to provide an education to all of its children.
Mm-hmm, that's correct. A free and equitable education, I believe, is the term.
Right. So there's essentially so where's the line drawn? I mean, the parents, they have their rights. I mean, my rights certainly aren't infringed, and I'm going to bring my child up as I see fit. Education, the school system is going to educate the child based upon state policy, but that's
why state policy should be very careful about treading in areas that impinge upon a parent's rights.
But that's not going to limit my education of my child. I mean, by way of example, I remember growing up in and things that I were taught, essentially about Columbus coming and discovering America and the like. You find out later that it wasn't necessarily accurate. I supplemented my education myself, not necessarily depending on the state.
Correct.
I do the same thing for my children. They get whatever they get from the school system. School system teach some things that I probably wouldn't teach, but I have no problem with it. Education isn't going to necessarily harm my children, but this goes, this is real broad. Education, care, what is care?
Direct the care of your children. It is both the parent's fundamental right to direct that. If the state believes that a parent is not meeting that, they would have to show that by it would be a standard that it would be by putting in law would be the standard the state would have to show that. It would, I'm not sure that it would change much right now on that than it is now. You can't, that there's standards for health, but anytime you start to say that a state's education system is going to dictate things that are beyond just learning and that's when you would start to have an issue. So beyond just learning I'm trying to think how to phrase it properly. It's putting it in the constitutional standard, much like we just talked about with a different constitutional amendment. Why did we want to put reproductive freedom in the state constitution? I didn't vote to put it in the state constitution, but why did many of you in this room want to do that? Because you said you wanted to make it very clear that that is the legal standard by which everything should be judged, and that the state would have to prove that there was a compelling reason why that should be superseded. And this is not putting it in the state constitution, but it's putting it in state law it's the standard we really are already probably I bet if we had lawyers in here from different state agencies, they would probably argue we're already doing this.
Right.
I don't know that we are, but why not? We should put it in law to make it very clear, because then there's a clear legal standard in state law that you can if there are things that come up, it can be adjudicated in front of a judge.
It goes back to my question. What is care? To direct the care of the parent's child.
Well, how your child will live their life when they are a child, taking care of them. I'm not sure if the Supreme Court defines the term care, and I did not define care, I admit, here in the bill. I guess we could, if you'd like to add a description of what care is, you're welcome to try, but
No, I'm just trying to
it's
understand.
supposed to be broad. It's
narrow.
supposed to be broad because we want to give broad authority to the parents who are ultimately also responsible for their children.
I guess I'm just of the mindset that I have the fundamental right to direct my child's upbringing.
Yeah, we just want to put it in
education,
state law to make it clear.
Thank you.
All right.
Thank you, Mr. Chairman.
Seeing no further questions from the committee, thank you all very much. Thank you. All right, we'll now turn to the virtual proponents of the bill. And so we have Mr. Russell. You are up. Welcome.
Good afternoon. Good afternoon. Proverbs 19:18 says, when their father develops the child and disciplines the child, there is much hope for us all. I'm in favor of the bill, making sure that in particular fathers have access to their children in this particular way to develop them. I think too many times it's not the case. And as a result, there are right now about 600,000 police officers in the United States. It's down by almost 40,000. The membership is down by 35 to 40% nationwide. There is now 1.5 officers per every 1,000 citizens in the United States. Teachers down by 35%. The number one complaint for officers and teachers in over 32 articles was the fatherless children. That too many times the teachers and the officers have to deal with children who are not fathered. Out of the top 103 professions, judges and attorneys are now leading in alcoholism, all kinds of things, depression, suicide, that have to oversee these cases because too often the system is set up to remove the families and to break them apart. There are 1.5 million false accusations that go out per year, proven false accusations. There's 37.5 million in the past 20 years that were proven, many of them against fathers, to in fact get positioning in custody cases when it should just simply be 50-50 custody and give the right to the fathers to be able to be a much more part of the child's life for development for all of our safety as a result. So in America right now, America makes up 4% of the planet, but we are considered the most unfathered nation in written history. Almost a third of the United States have some sort of mental health issue, and most cases is connected to fatherlessness. So I just came to be in favor of the bill because I really believe that we have a right as human beings to be fathered and to be developed by a father and have him as a huge proponent. Throughout Africa and most parts of the world,
Excellent. Thank you very much, Mr. Russell. Seeing no questions from the committee, thank you for being here. Thank you for taking the time to testify. All right, is Mr. Robusto in the room? It's a little bit garbled. Let's check your connection. Can you turn?
I will try it and here, let me get you off of Bluetooth, thanks.
Can you turn on your camera?
Yeah, I'm driving my car right now. I apologize. If I'm a disruption, I've sent in written comments, but I can be very brief by phone if you want me to talk.
Excellent. Go ahead.
All right, I'll be very brief. I don't understand why we even have to do this, but it all comes down to trust. I don't trust the government to do the right thing for my child, my grandchildren. I don't want them to look out for their health, their care, or their education. That's the responsibility of parents. And the only opposition that I can hear for doing that is you all don't trust the parents. That's too bad. I'm 100% in support of this bill. I encourage everyone to vote for it, and that's all I have to say. Thank you.
Excellent. Thank you very much. Be safe. All right.
Yes, sir.
All right. Thanks a lot. Have a good one. Questions? No questions? All right. With that, that'll end the testimony for the proponents of the bill. We'll now switch over to the opposition panel. We'll go to the opposition panel testifying in person. Is Sieber Cavazos here? And then Rosie Bean. Is Ayo Kamathi? Lauren Pruitt. All right.
I'm Nicole Hollywood. I meant.
Come on, yeah, come on up. Yes, that's right. We had you in the last one. Come on up.
Thank you, Chairman Smith and Vice Chair Waldstreicher. I'm Nicole Hollywood. I'm a 18-year professor in the University System of Maryland. I'm also a parent. I'm here today on behalf of Salisbury PFLAG. At Salisbury PFLAG, we recognize that a robust curriculum builds knowledge and extends perspectives. This means that students need to both see themselves in what they're reading, studying, and learning as a reflection of themselves and their histories, but also must be encouraged to see outwards and consider perspectives and experiences different from their own. We know that exposing learners to limited and skewed versions of history, health, or literature that neglect entire populations using insular and homogeneous materials forces them to develop a skewed, inaccurate version of the diversity of our society. This is particularly problematic for underrepresented groups, particularly LGBTQIA students and students of color. And the result is the creation of a hostile and unsupportive educational climate that research shows contributes to lower academic performance. Emboldening closed-minded people with the opportunity to object to curriculum and other materials based on beliefs about morality, religion, personal philosophy, or political ideology is dangerous and only promotes intolerance and tunnel vision. I'm going to read a quote from a teacher in Wacomico County Public Schools who said, "I'm a first grade teacher in Wacomico County and I teach primarily students of color. If parents are allowed to object to a curriculum that doesn't teach the history of my students, also known as American history, my students will suffer. My school is an amazing place that offers plentiful opportunities for students to see themselves and celebrate who they are. My students see themselves represented in literature and programming. We have artists come in and teach core curriculum through the arts and after-school programming. This will all go away if SB 566 is passed. The climate, morale, and culture of my school and all schools across Maryland will deteriorate. The title of this bill sounds nice on paper, but the ramifications of it being passed are not nice. Of course, parents should be a part of their child's education, but the thing is, parents have always had a say and will continue to have a say whether this bill passes or not. At any time, parents can go to a Board of Education website and see curriculum documents or log on to family portals. Thank you.
Good afternoon. Can you hear me? Okay. Good afternoon, members of the Senate Judiciary Committee. My name is Vienna Cavazos, or Cesar Cavazos, Vienna Cavazos. I, like many here, wish for a proper and firm education for Maryland students. This is what makes us one of the greatest states in the country, at least education-wise. However, because of our great education, this is why I oppose Senate Bill 566. This bill can be used by parents with misguided intent to shield their children from the real world, to shield their children from history that may differ with their own beliefs. Students are encouraged to see outwards from themselves as well as those around them. They're encouraged to look at our history, look at our past, and create their own judgment and views. We all agree that exposing students to skewed versions, right or left, can create unhealthy versions of and misinformed people. I myself am not a parent, but I work with parents. And we know that when parents work to support teachers in schools, the result is enhanced learners' abilities to further their education. The entire point of the education system is to teach our children. And that's what we want to do in Maryland schools. We want to teach children. We, as much as we value parental input, or yes, there are some things that parents may object to, and that's okay. However, demanding that their child be removed from that curriculum, the proponent of the bill in itself is very vague, very broad. So this could go from health studies to mathematics. To go on what Senator Sidnor said, I personally did not learn about the truths of Columbus. Okay, well, thank you.
Good afternoon. My name is Lauren Pruitt, and I'm the legal director for Free State Justice. I'm here today in opposition of Senate Bill 566. Parents already have much discretion for their children's upbringing. All parents have choices such as educational options, team sports involvement, activities, participation, medical decisions, religion and the practice thereof, community involvement, access to technology, social media, friends, relationships, entertainment choices, travel, just to name a few. I have 2 children, 10 and 7, both in public school, and my experiences are vastly different, I guess, than the other parents testifying. The fact that the proponents of this bill believe that it would overrule healthcare regulations stemming from a deadly pandemic is horrifying. I personally don't want any parents making decisions for my children without appropriate professional expertise that you would see from Department of Health or Department of Education. I heard over and over about a parent's rights, but what about the child? Many of the processes that schools have implemented giving children more discretion are because they are trying to protect children who have varying support at home. If your children are questioning your beliefs at home, I would look internally, not blame the government. If they do not want the school to notify you of issues at school, I would look internally, not blame the government. If they don't want their doctor to share information with you, I would look internally and not blame the government. Also, what about the guardians of children removed from their parents? Are we looking to give parental rights back to those parents whose children have been removed from their custody? And as an LGBTQIA plus advocacy organization, I'd be remiss if I did not realize much of the arguments over parental rights today center on parents wanting to exclude the mention of our community in school curriculums, in health education, or allowing their children the freedom to be whoever they are, including a member of our community. These vague, limited rights given to parents by this bill are overwhelmingly outweighed by the potential unintended and harmful consequences of this bill to our various systems and the futures of all of our children. For these reasons, Free State Justice opposes Senate Bill 566 and urges an unfavorable report. Thank you.
Thank you so much, Mr. Chairman. I'm just so curious. I have to hear the end of your story about Columbus. So if you don't mind, I'll give you 20 more seconds to wrap it up.
Much like Senator Sidnor, I personally went in, did more research beyond what was given to me through textbooks. And I have my own opinions. I'm sure everyone on this committee has their own opinions, of which I will not be sharing. But the idea that some things are not in our textbooks and that parents could object to me even having the notion of learning more than what is given. Like he said, Senator Sidnor, going beyond school and doing personal, I guess investigations would be the word. Thank you.
Thank you, Mr. Chairman. Can I ask a question of the First Lady who spoke? I may not have been listening carefully, but I thought I heard you say that the people who are supporting this bill are closed-minded. Is that what you said?
Well, it's a Moms for Liberty bill, so that pretty much speaks for itself.
So the members of the Moms of Liberty organization are closed-minded in your view?
Well, when you use words like we oppose gender ideology, that certainly isn't kind speech towards the LGBTQIA plus community.
Thanks. Well, let me just finish with one other. Isn't it correct that as recently as maybe 20 years ago, people teaching in school was that people who are male, who don't identify as male and heterosexual, and women who don't identify as women and heterosexual are abnormal? Wasn't that what the schools taught as recently as 20 years ago?
No.
No?
I never learned that in schools, and I'm certainly older than, I've been out of schools more than 20 years.
Okay, well, maybe I'm older.
It's also,
I'm older than you. Let me say 40 years ago.
Right.
Was there not a time in American history?
there was a time, yes.
Schools taught that.
Yes, there was
Yes.
a time in American history.
And at
The
that
DVSM
time-
has changed. There's no longer considered a psychological deficit or illness if you're LGBTQ.
If you'd been a parent at that period of time, would you have been comfortable with the schools teaching your children that being other than straight was abnormal? Would you have been comfortable with that?
No, but I would have had the right, like all the parents in the state of Maryland, to go to a school board meeting and to voice my opinion. So nobody's being censored. Parents are not locked out of school board meetings. Their parents can join the PTA. There are many opportunities to be active in your child's school.
Okay, so
There's also
your view is today
private
if parents
schools.
are unhappy with what's going on in their schools, they don't have the right to influence the curriculum other than going to a school board meeting and complaining.
But they have multiple opportunities
To
and
go to school board meetings.
they can go to school board meetings, they could talk to teachers, they can go to the Board of Education. So there are opportunities to use your voice.
Right. And if it gets nowhere, your feeling is the parents should simply pound sand, right?
Well, we also, so if you mean if someone's religious ideology should infringe on the acknowledgement of the existence of children like mine, yes, I'm sorry if they're a little disappointed. Gay kids exist, trans kids exist. I'm sorry for you if it's upsetting, but we do, our children exist.
Thank you very much.
Okay. Further questions from the committee? Okay, thank you all very much. Thank you. With that, that will end the hearing for Senate Bill 566. We'll now move on with Senator Waldstreicher with Senate Bill 683. Mr. Vice Chair, you're up.
Well, thank you, Mr. Chairman. Always a pleasure to be here before you and the committee. This is a little bit of a topic change from the previous couple bills here. We have legal fictions in our society. Those legal fictions are important and are useful. Corporations aren't people, but corporations are a legal fictionhood to which we ascribe peoplehood. And it's necessary so that we allow investors to invest in our business and we allow people to sue corporations. Corporations can be charged criminally. It's a useful tool and a useful legal fiction. But some legal fictions that we have in our code become so attenuated from real life that they can do real damage to real people. And this bill is about one of those legal fictions. And you're just going to be outraged when you hear kind of how this works and why it happens. Senator West is kind of the king of hypotheticals here, but I'm going to try to adopt one of my own. So imagine two cars going down the road in opposite directions. There's a man in one, a woman in another. The man crosses the yellow line and the double yellow, and a horrific car accident occurs. The man passes away, the woman lives. So the man comes from modest means. The estate is settled because the financial complexities are relatively little. And but the woman's life is altered because of the car accident, and she has severe physical damages from the accident. An accident reconstruction happens, as Senator Folden is experienced with, and it turns out that the man crossed the double yellow line before striking the woman. So in order to recover for her damages, the woman sues the man, except the man has passed. And so this procedure happens. The woman's attorney calls up the surviving spouse, the widow of the man, and this is how the conversation goes. Hi, I represent so-and-so. I'm so sorry that your husband passed away. I represent the other person in that car accident. I wanted to let you know that we're opening up an estate in your husband's name. And not only am I opening up an estate in your husband's name, I am suing that estate. And do you have any say in this matter? I'm sorry, you do not. See you in court. That's the phone call that has to happen. And as you might imagine, it's deeply hurtful for the widow or the surviving spouse or the heir to the estate to receive such a phone call. And it's nonsensical. And it's because of this legal fiction that we have where someone, after an estate is closed, who needs to sue the person who has passed, has to, out of whole cloth, create a new estate to sue. There is a better way. There's a way to do this without requiring an attorney to call the widow of someone who has passed in a terrible accident. And the solution is they should simply serve the policy. The estate has already been closed, but something survives the decedent, and that is the decedent's policy. This allows two sophisticated parties, the underwriter of the policy and the attorney who represents the surviving victim to work it out without having to bring the widow of the decedent into the case. And so that's what the bill in front of you does. What it does simply is it eliminates the antiquated process of establishing an estate solely for the service of process, and instead provides accident victims with a more respectful path to justice. We have so many bills here in this committee that seem to benefit plaintiffs or seem to benefit defendants. This bill benefits both. The plaintiff does not have to open a estate in the name of a dead person that they've never met. And the defendant does not have to be on the receiving end of the phone call notifying them that their loved one is having an estate open solely for the purpose of suit. With that, I'll ask for a favorable report for Senate Bill 683. And we are fortunate to have someone here with us who can describe these phone calls in graphic detail and unfortunately has had to make many of them. So I'll defer to Mr. Goldberg.
Good afternoon. Thank you very much for being willing to listen to my testimony. My name is Scott Goldstein. I've been representing injured individuals in the state of Maryland for the last 40 years. When an individual who causes a wrong dies prior to the installation or prior to the initiation of a lawsuit, it's my responsibility to then go out and open an estate for someone that I am adverse to at cost to my client, at inconvenience to my client, at time consumption to my client. Rather than having to open an estate that places a burden on the Register of Wills office, places a burden on the orphans court, places a burden on the plaintiffs, I am simply asking that we simplify the process into a common sense technique that will allow for service of process in rem on a thing. The thing in this case is the insurance policy. As soon as an estate is opened up, and I have opened in the last 20 years, probably 20 different estates for deceased defendants that never had an estate. I have my secretary or my paralegal appointed as the personal representative. I then have to have my secretary or paralegal served with process, who then merely turns it over to the insurance company for the adverse party. The estate immediately closes. The personal representative is never heard from again. It is a legal fiction. It is an obstacle. It is an antiquated way. It is antithetical to the common sense administration of justice and access to the court system by injured individuals. They've already been victimized once by a negligent driver who loses their life or dies subsequently. Don't let the legal system victimize them again by making them jump through hoops, open estates for the sole purpose of having access to a lawsuit. Thank you.
And I'm not sure if this goes to, I guess, to Mr. Goldstein rather than the sponsor. But I'm looking at the opposition letter from the Maryland Association of Mutual Insurance Companies, and they say that they're not aware of any factual situations where this has ever occurred in Maryland. So I'm hearing from you that 20 times. Have any of those been in Maryland?
Every one of them's been in Maryland.
So their facts might be
I have
wrong.
only practiced in this state for the last 20 years. So what happens is when you file a lawsuit, you must be able to name an entity. If John Jones crosses the center line and strikes my client, and John Jones passes away, I can't name John Jones as a defendant. I must name either an estate, or our proposition is you would name a liability insurance policy. The trade-off that we are willing to make, and that is part of this bill, and is very important, is it provides protection to the defendants, because the amount of recovery in that lawsuit would be limited to the policy limit that was in effect on the date of the accident. So this bill not only clears obstacles for plaintiffs, but it provides protection to defendants that their families cannot be victimized by excess verdicts.
So the other part of their suggestion in their opposition letter is that they recommend that any party making a claim under this situation should submit the matter to the Maryland Insurance Commissioner, which is charged with enforcing provisions of the Unfair Claims Settlement Practices Act. Do you think that's adequate?
No, that is not adequate because that's not the remedy at all. Because it's an unfair claims practice act for an insurance company to come forward and make an offer that they deem to be appropriate. And my client says is inadequate to fairly compensate them for their damages. So my client has the right to reject that offer, and my client has the right to then initiate a legal proceeding. Unless they are suggesting that the Maryland Insurance Commissioner should accept service of process. And in fact, that's what happens now. When we file suit against an insurance company under appropriate circumstances, there are direct action suits against insurance companies. The MIA is the authorized agent to accept service of process. We're not asking for anything any differently here. We're just asking to clear the obstacle of requiring estates to be opened when I'm adverse to the person for whom I'm opening an estate. I can't think of anything. When I tell people that I actually have to do this on occasion, they think it's unthinkable.
Thank you, Mr. Chairman. Could I talk to the sponsor of the bill? Thank you. I've got a couple of questions.
Okay, let's do it.
Question number one, this deals with estates and trusts issues. Did anyone run this bill by the members of the Estates and Trust section of the Maryland State Bar Association so they could take a look at it and come back with a response?
So I'm happy to have them look at it. I think they would come to the same conclusion that we have here.
Okay.
But yeah, happy to do it.
That's the first thing if that I would recommend happen. Second, you gave a hypothetical. Let me hit you with a counter hypothetical. Someone dies and the person has a number of pieces of rental property and he has stock, significant amount of stock. And the estates open up. Now, if for the person in the other car, in your case, should we establish an in rem action against the property, the rental property? So the person could file suit against the rental properties in order to get judgments against them and therefore liquidate the judgments by foreclosing on the rental properties?
So tell me if I'm not following here. If the estate is still open at the time of suit, then Mr. Goldstein can sue the estate. It's only after the estate has been
Let's assume it's closed. And he left everything to his spouse.
Okay.
And so the estate's closed. The spouse now owns the rental property. She owns the stock.
Right.
And she also has whatever other assets that were in the estate, including the insurance policy. So you want to create an in rem action against the insurance company. Do you also want to create an in rem action against the rental properties?
Of course not. She is not the defendant. In your hypothetical, the widow is not the defendant, and the person to whom the estate benefits is not the defendant. The defendant is the deceased. And so we're trying to get around this absurd phone call that has to happen. And
wouldn't the phone, in my hypothetical, wouldn't there have to be a phone call? Wouldn't you someone have to call the spouse who's inherited everything and said, got some bad news for you. I'm going to file suit against either the estate or you in order to recover the amount of money that my client is due.
So I'll turn it over to Scott, but the policy is not inheritable. The policy survives the person's death. So
does the rental property and the stock.
Sure, but it converts to that person's ownership, whereas the policy does not. You do not become the owner. If your spouse were to pass away, you do not become the owner of that person's car insurance policy. That car insurance policy continues to insure against acts that happened while the decedent was alive. So the reason this is going at the policy is not because the surviving spouse is the owner of that policy, but because the policy was written to protect against damages during the lifetime of the person who has passed.
Okay, Mr. Yost, do you want to add anything to that?
Yes, I do, Senator. What you're failing to understand by the nature of your question, quite frankly, is that when one establishes an estate, there is a period of time for creditors to come forward and to make notifications of potential claims against the estate.
Absolutely.
Those claims are not limited to the value of an insurance policy. They may extend to assets that the individual owned. In most of the instances that I'm referring to, no estate has ever been opened. People die intestate, they die without assets, or they die with merely a spouse. And when they die with a spouse in the state of Maryland, most property will pass to the co-owner. Real estate, we already have a provision for it to pass to the co-owner. What we are talking about are circumstances where there has been no estate. If there is the estate, as you indicate, then you're right, quite frankly. Assets in the estate are fair game in the event the individual is not properly insured. Most people in the state of Maryland do carry what's called underinsured coverage, which provides coverage to them in the event that the defendant has inadequate coverage. So the hypothetical that you pose, while it is possible, it is extremely unlikely and usually does not occur.
Well, let me go back then. The whole premise of this bill, as I understood from the sponsor, was that we want to prevent the widow in the hypothetical situation from receiving a phone call which will distress her. And
Well, then-
therefore, we don't want to have to open an estate and let her know that you're opening an estate. You just want to go directly against the insurance company. But if you're going to make a claim against the rental property, which she now is going to own thanks to the will, and the stock, which she's now going to own against the will, there's going to be a telephone call, I'll guarantee you, is there not, to the spouse, which is going to be distressing.
First of all, there's not going to be a phone call to the spouse, because what's going to happen is there is a clear and direct and established legal process for making claims against open estates. Attorneys do it all the time. Hospitals do it all the time. It's done in a number of different ways.
But excuse me, there is currently an established legal process for recovering from an insurance company, which is you open an estate and you file a claim against the estate, and the state then claims against the insurance company. That's established too, isn't it?
We have placed it by doing so, by engaging in the legal fiction of having me counsel for the injured party to establish an estate for the defendant that I am adverse to is nonsensical. What we're talking about is limiting the claim to the amount of insurance coverage that's available. We are reducing the burdens. You ask about the impact of estates and trusts. We are reducing the burdens on the Register of Wills office. We are reducing the burdens on the Orphans Court. We are promoting judicial economy. And most importantly, we are promoting access to the civil justice system by victimized, injured individuals and not making them jump through hoops and deal with obstacles that are antiquated and serve no legitimate legal purpose.
Okay, great. Thank you for your answers.
To the gentleman, before asking any questions, I sort of want to understand how a case proceeds currently. You have to open the estate for presumably the spouse, okay?
Okay,
And the deceased had an insurance policy.
correct.
I assume liability has not been, there's no way liability has been established regarding the accident. So you open the estate, there's an insurance policy. As you know, insurance policies aren't, referenced on it in a trial for liability. So what's the trial like?
Okay, so what
Currently?
What happens in that circumstance is that I have to go out, I have to open the estate. I serve one of the employees of my office. They turn that over to the adverse insurance company. That insurance company then appoints counsel of record. That counsel of record sits at a trial table, either by themselves or potentially with a family member, if the family member is interested enough to appear rather. Typically they don't, and the case goes forward. Whether there is an estate or not is irrelevant, because quite frankly, under an automobile liability insurance policy, the insured, in this case, the deceased insured, has no right of advice or consent. They can't tell the insurance company, we want you to settle. They can't tell the insurance company, we don't want you to settle. The insurance company and their attorney and their adjusters make all of the decisions with respect to that case.
I do this work, so thank you for explaining that. But anyway, so let's assume at that trial, you don't succeed.
That's the chance that we take.
Okay. Now, normally, and haven't heard the sponsor you address it, and you can follow up, but you know, there's basic longstanding ways we deal with insurance policies and their and whether they're known during a trial. And there's reasons you know, for them not to be known. The question is whether the individual, deceased or not, is liable for the accident.
That's correct.
So the insurance company and the policy itself has no involvement in the case, if you will, unless liability attaches to the decedent, right?
Well, that's not necessarily true. There are many instances where insurance is named during the course of a motor vehicle accident case. If I am suing an individual who is not properly insured, they don't have adequate insurance, they have the minimum of the state, and my client has underinsured motorist policies, they've exceeded the amount, I am allowed to sue not only the deceased, the defendant, who is the tortfeasor, but I'm allowed to sue that insurance company as well. Having an insurance company named as a part of a legal proceeding does not in any way prejudice the insurance company. It merely states a legal fact and it erases a fiction. I would suggest to you, Senator, that where the real damage comes in is when I'm suing an individual and the jurors are under the mistaken belief that that individual is the one that's going to be paying the judgment, when in fact, it's a multi-billion-dollar international insurance company that's paying the judgment. But my client has to live with the fact that the jurors are going to feel guilty that they're rendering a verdict against that poor individual. I can tell you that I have been approached by jurors after trials, and they'll say things to me like, Mr. Goldstein, how's that nice young man going to pay that judgment? And I'll say, ma'am, do you own a motor vehicle? Yes, I do. And is it insured? Yes. And I've had jurors say to me, if I knew that the insurance company was going to be paying, I would have been fairer to your client. I would not have been prejudicial to the insurance company. I would have been fairer to the victimized, injured individual. That's who we need to protect, not multinational corporations.
All right, you have, you're an advocate, but there's another side to it. But you know, you're so passionate that I think we'll drop the conversation and we'll move on. It's too much.
Because it's too practical.
I wish Senator James would give up on my line of questioning that easily. Oh my gosh, yeah, you let him off easy this time.
Oh my God, it would go on for an hour, and you know, it would be interesting, but
I believe he would. That's right. All right, additional questions for the panelists. This has been an interesting conversation. Thank you very much.
Thank you.
All right. We have one other proponent joining us virtually. I think, is Mr. Yost still here in the waiting room?
Yes.
Welcome. You're up.
Can you hear me?
We can hear you, but we cannot see you.
Not sure why. Well, let me go without being seen then. Good afternoon, Chairman Smith, Vice Chair Waldstreicher, Senators. My name is Tom Yost. I am here on behalf of the Maryland Association for Justice, and I urge you to report favorably on Senate Bill 683. You have had a great discussion already. And you know, just a few highlights. The bill limits the addendum clause, what you're asking for, to the policy limits of the insurance company. There's no extra liability for the insurance company, number one. Number two, it's only when an estate isn't open. Somebody's wealthy and has lots of assets that are in their estate, somebody in their family is going to probate the will and open an estate. If they don't, you know, someone has to open an estate. I too have had to open estates for deceased tortfeasors when no one else did. So that's a fiction. If it's never happened, it's probably something insurance companies just don't track. The bottom line with this is that this expedites the matter, and it does, you know, it kind of effectuates a kindness to the family members, because when you open an estate, you have to mail your request to open the estate to all of the people that could inherit, which would be a spouse, heirs, parents of the deceased. They all get a copy of it, and there's a hearing date set. So they don't have enough sense to just sign the paper and say, I consent to the lawyer being the personal representative of our loved one's estate. So what happens is that they have to wait, and then there's a hearing, and when they don't show up, the lawyer gets appointed or someone in the lawyer's office gets appointed. Now the lawyer's in charge of that estate. They don't really need it other than to accept service. But they have to go through this process. The family gets mail, family gets a phone call to have it explained to them. And, maybe the insurance company doesn't know about it or doesn't do anything about it. But once service has been effectuated, then you can sue. You can sue and serve another person in your law firm, which is kind of crazy. Other states have direct actions. Maryland has it in limited first-party situations, but other states do sue State Farm or Nationwide or Allstate directly. For some reason, Maryland has clung on to this idea that jurors may somehow be prejudiced, but people know that people buy insurance. There's no prejudice there. And, this committee has also dealt with the direct action bill before, which is passed.
Thank you, Mr. Yes, sir. Your time's up. Thank you very much.
Thank you.
Thank you. Questions from the committee for Mr. Yost? All right, seeing none. Thank you very much, Mr. Yost.
Thank you so much.
Thanks. With that, that'll conclude the testimony for the proponents of the bill. And I'll hear from the opposition panel. And if Mr. Enton and is Miss Harding here? I see Marta. How are you? Come on up.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the American Property Casualty Insurers Association. Our member companies write about 60% of the auto insurance in the state of Maryland. It's interesting to listen to the proponents' testimony. And I would just response to something they said and Senator West said. When you look at the Estates and Trust article, section 8104, and if you have any interest in passing this bill, I would ask you to please look at that. It sets out in subsection E a detailed process specifically for decedents covered by liability insurance policies. This issue is extensively dealt with under current Maryland law. It provides that its existence of insurance coverage is not admissible in the trial of the case. Now you might ask, well, why is that? The reason is that longstanding Maryland law has always recognized exactly what the proponents said. And that is that if the insurance company is the defendant at the table, you're going to see a huge spike in the amount of the damages. This is a claim between the injured party and the party who allegedly committed the harm, or if the party is deceased by the decedent's estate. To create this in rem action against an insurance policy itself. Have you ever heard of that? The Court of Appeals if you look at the testimony, you've got written testimony from almost every large insurer and insurance company trade association in the state. But what caught my attention in the testimony of my client was the quote from the Court of Appeals in the case of Allstate versus Atwood. The policy of the law is firmly against the injection in tort trials of liability insurance. The matter of liability insurance is irrelevant to the issues of the defendant's liability and is highly prejudicial. That's why a statute like this doesn't exist under the laws of the state of Maryland. And that's why insurance companies are not named as defendants, because it is highly prejudicial. There's a process that's been on the books for years. It works. Maybe the plaintiff's bar has to go to a little more trouble than they would if they could just serve the defendant. But that's what we have, and that's what works. So we would urge an unfavorable report on this bill. Thank you. I'm happy to answer any questions.
We'll take questions at the end of the panel.
Sure.
Thank you, Mr. Enton.
Thank you, Mr. Chairman, members of the committee. Marta Harding here on behalf of State Farm. I won't repeat what Mr. Enton said. We share the concerns and share the belief that there is a full remedy under current law that's worked just fine for many years. It may be more of a problem than if in other circumstances, but it's not a reason to just dispense with what has worked. Personal injury actions are actions against an individual, not against a policy or an insurance company. Third-party claimants, the Court of Appeals has described them as strangers to the insurance policy. And they only come into play when and if there is a final judgment or settlement against the insured. I just want to respond to one thing I heard from the proponents of the bill, that this helps the defendant by capping liability at the policy limits. I think it's important to note that this is the decision of the plaintiff's lawyer. If the defendant has assets, they can go against the defendants in the traditional way they always have. If they don't, then this is the process that they can turn to. Again, it's in the hands of the plaintiffs, but it doesn't necessarily help defendants at all or their estates. So for those reasons and for the reasons you heard from Mr. Enton, we would urge an unfavorable report. Thank you.
Thank you very much. Ms. Harding, questions from the committee? All right, seeing none, thank you all very much. With that, that'll conclude the testimony and the hearing for Senate Bill 683. We'll now move on to Senator Carter. Senator Carter, which one would you like to take? Senate Bill 6. All right, we'll go with Senate Bill 653.
Good afternoon on this final bill hearing day for my bills committee. And Mr. Chairman, I know you're happy. Let's reason to celebrate. I'd like to bring up my panel, which is Erica Lamont, Advocacy Director for Children's Rights, and Natasha Alfani from, I say it wrong all the time, I'm sorry, Calfany, Office of the Public Defender. We heard this bill last year, and I hope that we can really move forward with it this year. The people of Maryland have spoken about the legalization of marijuana, and what was brought to our attention by this bill last year by persons working in the area of child abuse and neglect Senate cases is that marijuana continues to be a reason to keep parents away from their children. And so this bill seeks to deal only with children that are placed in Senate cases, children that are placed in foster care because of parental drug abuse or drug use. Among the number of those children were children whose parents used only marijuana and no other drugs. While typically not the only issue when children are brought before the Senate or Senate cases, marijuana is generally used as additional evidence against parents challenging their ability to care for their children. Far too often, for many parents, cannabis can be the sole barrier to them regaining custody of their children. Even for parents who have been denied by the court, have successfully addressed issues of parenting, mental health, housing, etc. A positive toxicology for cannabis could be the sole basis for preventing reunification. Mr. Chair, thank you. With that, I think we can get a favorable already. It's important to separate cannabis use from allegations of abuse. I'll repeat that. It's important to separate cannabis use from allegations of abuse. The two are not synonymous. There is no science or evidence to support family separation based solely upon parental cannabis use. Like alcohol use, cannabis use alone does not predict a parental deficiency. It's only when the use of alcohol or cannabis causes parental neglect and abuse that such use should be considered. In an article published by the imprint, it was reported that well-off parents have publicly testified to the calming effects of marijuana, openly participating in groups like Moms for Marijuana, while less affluent parents are often held to a different standard, finding themselves accused of being unfit to raise their children if they use marijuana even occasionally. You have my written testimony. I think it's important to note that other states have already passed these laws, notably Texas, New York, Massachusetts among them. And so this isn't an exotic concept. I think it just is in line with where we're going as a state in terms of the legalization of marijuana. I want to just briefly address, I remember some questions last year by some of the members who said, oh, well, does this stop someone from it being considered if you're smoking marijuana in front of your kids? Absolutely not. This just says that this marijuana use, the fact of someone's marijuana use is not a reason to either take their children or
fail to reunify them if they've complied with every other condition that they've been asked about. So with that, I'd like to hear from the witnesses and I'd move for a favorable report. Thank you. Yeah, sure, yes, thank you.
Good afternoon. My name is Natasha Calfany, and I am an attorney at the Office of the Public Defender, and I'm asking a favorable report. As Maryland addresses issues of legalization and decriminalization of cannabis, we must simultaneously address the negative impact cannabis has on parents who use. Cannabis has been used as a tool to allow government intrusion into the lives of people who are fit to care for their children. In the circumstance of a pregnant person using marijuana, even prescribed, cannabis use will at minimum result in DSS investigation and at worst could lead to removal of her infant, regardless of her ability to care for her child. For parents facing allegations of abuse or neglect for other reasons, if it is learned through investigation that a parent uses marijuana, at minimum, the parent is required to complete a drug assessment and/or drug treatment, but children are often removed from their parents' care until substance treatment is complete and the parent has achieved 90 days of sobriety. If a child is in foster care and a parent has complied with all court-ordered services but continues to use cannabis, that parent will be denied unsupervised visitation and reunification, even if that parent has remedied all other issues that brought the child into care. There is case law that says there has to be a nexus between a parent's drug use and harm to the child. That rule is largely ignored. Marijuana is not a parenting test, yet its usage is often a determining factor in whether a parent is able to provide proper care and attention to their child. This issue also has racial implications that mirror that of the criminal system, in that the same unequal surveillance and policing that results in Black people being arrested for marijuana possession at 3 times the rate of white people, despite the same rate of use, also draws families of color disproportionately into the child welfare system. As you will hear, contact with DSS, even minimal contact, can be harmful. We must prevent the unnecessary harm surrounding issues of cannabis use in parents. Thank you.
Good afternoon, Chair, members of the committee, and thank you, Senator Carter, for bringing this bill to light. My name is Erica Lamont. I'm the Advocacy Director for Children's Rights for Maryland Legal Aid. We represent children in need of assistance cases and termination of parental rights cases all across the state of Maryland in just about every county. I personally have been in this field for over 20 years. And we urge your support for Senate Bill 653. Maryland voters have approved the use of cannabis, but I mean, we have to admit that some people still have a very negative view of it. And what this bill does is keep the focus where it should be on if the issue, in this particular case, cannabis, if the cannabis use is directly related or related to harm or substantial risk of harm for the child, that's where we need to focus, not on whether we agree with it, whether we don't agree with it. It's does this impact or harm the child or have a substantial risk of harm? And keeping that focus on child safety is why this is such a well-written bill. I agree that there are cases where, and it depends on your jurisdiction, which is why we need to have something consistent. But it depends on your jurisdiction where parents, if they're still testing positive for marijuana, whether that's an impediment, that can be an impediment and keep kids in care longer and even prevent, as Ms. Kafani said, visitation, unsupervised visitation, and returning the child to the home. So we also believe that this will help prevent unnecessary separations from family, and we urge a favorable report. Thank you.
Okay, Ms. Richardson, if you can hear us, we're ready to go.
Thank you. I can hear you now. Thank you, Mr. Chairman, members of the committee. My name is Alexa Richardson, and I'm an attorney in the Parental Defense Division of the Office of the Public Defender and a midwife. OPD urges a favorable report of SB 653. In considering this bill, I urge the committee to take account of the severe and known harms to children of being separated from their parents. Cannabis use by a parent in no way poses the risk of harm to a child that separating that child from its parent does. At OPD, we often see new babies and young children being removed where a positive tox screen at birth for cannabis use is a contributing factor for removal, or positive tests during drug rehab prevent reunification over time. Early childhood is incredibly significant for a baby's neurological development, and current studies are clear that separation of an infant from the mother is a major physiologic stressor for the child. And the documented results of separation include developmental regression, difficulty sleeping, depression, and acute stress. It can lead to long-term medical conditions like cardiovascular disease, hypertension, obesity, and decreased longevity. Children separated from their parents in the first 2 years of their life score significantly lower on IQ tests, and they're nearly twice as likely to be arrested or criminally charged and more likely to have alcohol and substance abuse disorders. Separation of a mother or a new parent from their child at birth, in part due to a positive test for cannabis, is also traumatic for the parent. The trauma of this separation causes long-lasting damage to mostly low-income women and women of color and drives inequity in our state, ravaging the social fabric of low-income communities in Maryland. In the Parental Defense Division, we regularly see cannabis used by a parent used as a factor indicating neglect of a child and contributing to the removal and separation. I urge the committee to protect Maryland children from separation by removing cannabis as the sole reason to separate a child from its parents. Thank you.
Any questions? Yes, Senator Kelly.
Thank you. Hello, my question is for Ms. Richardson. It's lovely to see you here.
Hi, hello.
So I'm happy to see you. And I was interested in what you said about how you regularly see this used as a contributing factor. And I was wondering if you could just give me a couple of examples to help contextualize. I already liked this bill, but seeing you here in support of it is really convincing. So if you can give me some more information on that, I'd appreciate it.
Thank you. And it's so nice to see you. So, many hospitals in Maryland choose to universally test pregnant and birthing people at birth for substances. And if that test comes back positive for any substance, including marijuana, they're then required to report that parent to Child Protective Services. And once Child Protective Services, DSS, receives that report, they are then required to do some sort of screening or investigation and decide whether or not that baby can go home with that parent. And in those cases, all it can take is some other contributing factors, such as the home being determined to be too dirty, another substance use test coming back positive, some history with CPS, maybe having other children that have been in the system before, all sorts of factors, truancy, children having been absent from school before, things like that. So any other factors at that point can come into play and end up leading someone to have their brand new baby taken at birth, all triggered by basically a positive cannabis test at birth. And so those are some of the kinds of things that we can see spiral into a situation that then involves months or years of DSS involvement and very stressful situations for parents and children.
Thank you so much. That was a really helpful answer, and I really appreciate it. Thank you so much.
Thank you.
Okay, thank you. Any other questions? And this concludes the hearing. on 653, and Senator Carter, this is your last bill for this year, but great bill. 761, you're on.
Thank you very much, Mr. Chair. I'll say Chairman Muse, nice to have you today. I'd like to bring up my panel. I'm not sure if they're present or virtual, but the panel is Jamie Grace Alexander, Lauren Pruitt, and Sam Williamson. Yep, they're coming in. So those of you that were here last year may remember this bill, but I want to first stress that a lot of work has gone into fine tuning this bill from last year. And I think that what is before you today is a very well written and well thought out bill. The bill does, this bill is about dignity, respect, and safety. The bill requires, among other things, that our carceral institutions in our state, local and state, would add gender identity to an annual report that they already are forced to submit. And that's important because we really don't have any tracking of transgender individuals in our local and state institutions, which is very important. It also would require that all of these institutions have a policy of non-discrimination against persons based on gender identity and all other specified protected classes. You will hear some stories about different individuals. I've had personal experience with one individual woman that was abused in the Baltimore City Detention Center when I was physically present for another reason, seeing someone else. But it was a person who had volunteered for my campaign, and this person was abused actually at Baltimore City Detention Center by guards, by correctional officers. I remember that in a subsequent visit, after this person had been harmed, I asked the correctional officers about that person's fate, and they not only made light of the situation, but made jokes about the harm that they had caused to her, making jokes, frankly, just based on gender identity and lack of and discrimination and feel a feeling of comfort at being able to openly discriminate. Currently, transgender detainees are being placed in cells with individuals who are known to be violent toward transgender persons. There are noted cases of when transgender women that have refused violent housing, they have been punished and placed into administrative segregation, where they are only allowed out of their cells for 1 hour per day and lose access to programming, classes, and jobs, and they may lose accumulated good time credits because of it. The conditions in our institutions result in high levels of stress, fear, social isolation, infectious disease, and violence exposure, all of which can increase disability risks. Maryland prison conditions must punish incarcerated individuals, especially transgender women, by damaging their health and well-being. This bill will reduce some of the unjustifiable impacts. This bill also would bring Maryland into compliance with the prison rape, the PREA Act, Prison Rape Elimination Act, the PREA Act, which we are currently not in compliance with. It would allow LGBTQIA+ individuals to request transfers to gender appropriate facilities based upon their housing needs and overall safety concerns. The bill submitted last year was originally based on a California statute, and the California law has been an important step forward in protecting incarcerated transgender persons and has not led to disarray or increase in violence in California prisons. California has approximately 1,671 incarcerated gender, non-binary, and intersex individuals. In the 2 years since the California law was implemented, there have been 353 housing transfer requests, and only 13% have been approved, which is 47 approvals. I highlight that just to highlight that I think even though we don't have the numbers because Maryland doesn't report, I think it's safe to say that Maryland's numbers are likely less than that. And even where they have a large number of individuals, it hasn't resulted in the floodgates of multitudes of transfer requests that are frivolous or not warranted. The bill this year includes the definition of gender identity consistent with the way it's defined throughout Maryland's code. And that definition must be consistent and uniform, or have other evidence that gender identity is sincerely held as part of a person's core identity. I recall some suggestions by opposition testimony last year that this could cause people to pretend that they're a certain gender to be able to get into a cell to abuse people. But I think it's important, and I think it's actually kind of outrageous, because I don't really know of too many individuals that want to pretend to be transgender if they are not, or pretend to be a gender that they are not. I've never had that experience, and I can't imagine it would happen in incarcerated situations where violence is more likely. But at any rate, the belief has to be sincerely held, and there has to be some indication that this is how the person identified before the intake occurred. And so I think that's an adequate protection. The bill also tightens up language permitting the prison to deny transfer request. The bill now explicitly states that request may be denied based on risk that the inmate may commit abuse. These changes strike an appropriate balance to ensure that additional safety for all incarcerated Marylanders. And in sum, this bill would protect transgender and other individuals being subject to discrimination and violence, and provide a safer and more orderly prison system. For these reasons, I move a favorable report. Thank you.
All right. Hello, my name is Jamie Grace Alexander. I'm here representing Free State Justice, Maryland's legal and civil rights organization. Our community requires additional protection. This is acknowledged by federal law through the Prison Rape Elimination Act. PREA standards represent the start, but not the end of efforts to curb prison rape and sexual abuse. We take PREA one step further to allow transgender people not just to be placed into a housing assignment with their birth sex that is marginally safer than the general population, but to request transfer across currently sex-segregated prisons into a safer housing assignment with their lived gender. We believe that gendered housing that functions strictly off of assigned sex with no exception will always be additionally harmful to trans, queer, and gender variant people. Currently, correctional facilities policies regarding our community vary greatly from facility to facility. Some prisons have a designated wing, like the medical wing, where our community is housed separately from the general population. Most facilities house trans people within the general population of their assigned sex, though in a cell assignment with someone who they believe is a lesser risk of becoming their attacker. This is the federally legislated minimum under PREA. Disturbingly, some facilities who do not know what to do with their transgender inmates house them in involuntary administrative segregation or solitary confinement to avoid protecting them from the general population. A survey of over 1,000 LGBT incarcerated people found that 85% of participants were held in solitary confinement at least once during their sentence. Transgender individuals have frequently been placed into solitary confinement for being the victims of violence rather than the perpetrator. No facilities in Maryland currently house a transgender person outside of their sex, regardless of any gender-affirming surgeries a person may have had at the time of their incarceration. This legislation is a solution to problems that already exist. I can tell you with certainty that no one would transition and willingly expose themselves to the discrimination that we face in order to receive special treatment, because there is no special treatment. Indeed, such bad actors are prevented from doing so by this bill. Thank you.
Thank you. Thank you, Chair Smith, Vice Chair Waldstreicher, and members of the committee for the opportunity to share my support for SB 761. My name is Sam Williamson. My pronouns are they, them, and I'm a lawyer with Disability Rights Maryland. Disability Rights Maryland is a state's protection and advocacy organization. Our mandate is to protect the civil rights of people with disabilities. As part of our mandate, we monitor the state's correctional facilities. We have learned of transgender women being placed into cells with men who have threatened them and who are violent towards transgender women. As Senator Carter stated, these women are punished and placed into solitary confinement if they seek to have safe housing. This bill would only apply to DPSCS facilities. It would not apply to any local facilities that are not under the control of the Department of Public Safety and Correctional Services. DPSCS estimates that there are currently 78 incarcerated transgender people in their custody. Members of the committee who were present last year may remember that much of the hearing focused on how to balance the safety of incarcerated transgender people with the safety of incarcerated non-transgender women. We took the feedback from last year and we have struck a great balance to help protect everyone who is incarcerated. The bill now includes a definition of gender identity that is consistent throughout Maryland's code. The definition requires that gender identity be consistent and uniform, or have other evidence that gender identity is sincerely held as a part of the person's core identity. The bill also makes clear that correctional facilities retain the ultimate authority on where to house people. The bill clearly states that requests may be denied based on security concerns, such as a risk that the inmate may commit abuse if transferred. Because this bill improves the safety of incarcerated Marylanders, I urge the committee to issue a favorable report. Thank you.
Good afternoon. My name is Lauren Pruitt, and I'm the legal director for Free State Justice. I'm here today in support of Senate Bill 761. The regulations established by this bill will directly impact our most vulnerable LGBTQIA+ clients, those who are incarcerated and under the authority of DPSCS. I'm not here just in my capacity as a civil rights attorney, but also as a former correctional officer. Our community faces higher rates of incarceration than the general population. 16% of all transgender adults have been in prison or jail, compared to just under 3% of all adults. Our clients' complaints include the lack of access to medical treatments, hormone therapy, no access to necessities due to gender-based commissary forms. So a trans woman housed in a male facility has no immediate access to undergarments, feminine hygiene products. Many housing assignments are unsafe and leave individuals either in extended periods of solitary confinement or at risk for violent assaults. Solitary confinement means limited movement, limited phone use, limited access to programming, which is used to show you are being rehabilitated and subsequently slows a person's eligibility for various release programs. Maryland's Treasurer Derek Davis has called on DPSCS to exhibit restraint to avoid costly settlements. At the Board of Public Works meeting on March 1st, Treasurer Davis stated DPSCS is now on pace to pay out $42 million in settlements this year. This follows a recent settlement of $92,000 from a lawsuit in which a trans woman was denied treatment at the North Branch Correctional Institution. Although many opponents of this bill focus on housing and placements, this bill is not just a permission slip to go to the facility of your choosing. Housing determinations are still going to be made by DPSCS according to individual determinations of risk. What the bill does is creates a much needed process and standard for the safe and humane treatment of transgender incarcerated people as already required by law. This bill would put us closer to fulfilling DPSCS's mission of protecting the public, its employees and detainees and offenders under its supervision. Something as an officer I was forced to memorize, but every day at work was made to ignore. For these reasons, Free State Justice urges a favorable report on Senate Bill 761. Thank you.
All right, thank you all for your testimony. Questions from the committee? All right, seeing none, thank you all very much. Thank you, Senator Carter. Next, we'll hear from Nicole Hollywood, Lee Blinder, Sam Williamson. Oh, that was, sorry, yep, sorry that, and Caesar Cavazos. Is Erica McDonald. There you go. And then let's get Margot Quinlan. All right, whoever would like to go first.
Hi, I'm Nicole Hollywood. I'm a professor in the University System of Maryland for the past 18 years, and I'm here today as a representative of Salisbury PFLAG. Transgender and gender nonconforming inmates are often victims of gender-based and sexual violence, with the Bureau of Justice Statistics at the Department of Justice reporting that 40% of incarcerated transgender people have been sexually assaulted, a statistic that is more than 10 times the general prison population rate. Further, the National Center for Trans Equality reports that transgender people are 5 times as likely to be sexually assaulted by prison staff. Incarcerated members of the transgender community also face many other difficulties accessing gender affirming care, which the Department of Justice explained in a 2021 statement of interest in Diamond v. Ward violates the U.S. Constitution and the 8th Amendment's prohibition on cruel and unusual punishment when they refuse trans women placements at female facilities when needed for safety or deny trans people gender dysphoria care beyond hormone therapy without conducting individualized assessments of their needs. These protections and procedures would improve the experience of transgender, non-binary, and intersex inmates in the Maryland prison system, helping to ensure their safety. Because of this, PFLAG Salisbury supports SB 761 and recommends a favorable report in committee.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and the esteemed Senate Judicial Proceedings Committee. My name is Lee Blinder. I use they, them pronouns, and I'm a very proud non-binary transgender Marylander. In addition, I also serve as the policy chair of the Maryland Commission on LGBTQ Affairs, and this bill is a top priority for both entities. Both entities also, I'm the executive director of Trans Maryland. I also recently served on Governor Moore and Lieutenant Governor Miller's transition team. Trans Maryland is a multiracial, multi-gender community power building organization for Maryland's trans community. We hear from thousands of transgender Marylanders, including those who are currently and formerly incarcerated. Incarcerated transgender, non-binary, and intersex persons are particularly vulnerable members of our society. We wish to ensure that the gaps in DPSCS's confinement policies are closed and that this legislation is a crucial step towards that goal. Solitary confinement is being used by DPSCS due to lack of safe housing for LGBTQIA+ persons, a practice that is defined as torture by the United Nations, who condemn that its use in the United States. We are eager to collaborate with DPSCS to implement best practices moving forward. Our incarcerated transgender community members have directly shared with us the following experiences: lack of access to trained medical and mental health providers and medications, requirements to undergo mental health evaluation before initiation of gender affirming hormone therapy, a practice that is out of compliance with international standards of care that call for the informed consent model. Subjection to violence by fellow incarcerated persons or correctional officers due to their transgender status, intentional use by correctional officers and staff of their former legal names, post legal name change, intentional use of incorrect pronouns by correctional officers and staff, and lack of access to affirming gender appropriate commissary. We are eager again to see this bill pass, and for all these reasons, we urge a favorable report on SB 761. Thank you so much.
Good afternoon, Chair Smith and committee members. My name is Erica McDonald, and I'm testifying in support of Senate Bill 761 on behalf of the League of Women Voters of Maryland, representing concerned citizens throughout the state. The League believes that all correctional systems should provide humane, dignified, non-discriminatory treatment of incarcerated people. But incarcerated people in Maryland's correctional facilities are routinely discriminated against based on their gender identity. And current legal protections for incarcerated transgender people are inadequate to protect them from violence and harassment. Incarcerated transgender women are 10 times more likely to be victims of rape than cisgendered people. And incarcerated transgender people are often harmfully placed in solitary confinement against their wishes to protect them from violence. They're subject to these and other harassments continually in Maryland's correctional facilities. I'm also here today because I have a transgender adult son. As a transgender man, my son would be at high risk of victimization if he were to be incarcerated. I would want him to decide where he would feel safest were he to be incarcerated. He should not have to fear discrimination, harassment, and violence in a government facility because of his gender identity, and he does. He fears being pulled over for a traffic stop because of this. This is a 19-year-old who's at St. Mary's for college. It's abhorrent to me. It is unconscionable that we allow transgender people to be victimized in government facilities. I urge you on behalf of my family and the League of Women Voters to support SB 761. Thank you.
Hello, once again, members of the Senate Judiciary Committee. My name is Vienna Cavazos, and like many people here, I am in support for SB 761. I, as a transgender individual, my pronouns are they, them. I am at risk, not only as many of the many horrible things that are done to transgender inmates that was brought to light by other testimonies. But much like the previous testimony, I fear the possibility of incarceration due to my gender identity. The idea that because I identify as something outside of cisgender, can be discriminated against and harmed in a federal institution is beyond obscene. It goes beyond, one could say, I believe it's the 8th Amendment of the United States Constitution, cruel and unusual punishment. As explained before, incarcerated members of the transgender community face difficulties accessing gender-affirming care. And yes, the 8th Amendment. And these protections and procedures would improve the experiences of transgender, non-binary, and gender diverse inmates throughout Maryland, helping to ensure our safety, because we are people as well. We deserve the same rights and respect and decency that everyone else in this room gets. Because of this, I recommend a favorable report at committee. Thank you.
Great. Thank you, Chair Smith, Vice Chair Waldstreicher, members of the committee. My name is Margot Quinlan with the Mental Health Association of Maryland. We're here in strong support of this bill. And I just want to touch on the behavioral health aspects of this legislation. And so for the trans community, as folks are probably aware, we face the disproportionate levels of minority stress, which is the socially based and unique behavioral health conditions and symptoms from discrimination, from harassment, from violence, right? And so these can lead to, and the research shows that this leads to increased rates of depression, of anxiety, of suicidality, of substance use disorders. And it also is connected to our discrimination in housing and in the over policing and incarceration that we face as a community, as other folks have talked about. And then the sort of double arrow of all of this is that once we're incarcerated, then we face this overwhelming majority of us, 85% of LGBTQ folks in jails are put in solitary confinement for their protection, right? Not because of like anything that's being done by those people, but because of for their own protection and against their will. And so that is this double injury that is creating significant and really alarming behavioral health concerns. And so for that, we're really in strong support of what we see as a pretty technical and simple administrative fix that would bring us in alignment with federal regulations and in alignment with the federal dollars that we receive. And so we're really grateful for this committee for taking this up this late in session and hopeful that we can see this move forward, before the session ends. So thank you so much for your time and your support.
All right, thank you all very much. Questions from the committee? Seeing none, thank you all very much for being here. Thank you. All right, it's Nicole Wells. Jessica Emerson. Louisa Wayman. Melissa Murphy. Rosie Bean. And is Deborah Gardner. Whoever would like to start.
I can start.
Sure. Yeah.
Do I stand up?
Yes. Thank you.
Hello, everyone. My name is Nicole Wells. I am here in favor of Bill SB 761. I am also the lead case manager at Baltimore Safe Haven. Back in 2015, I was incarcerated at Baltimore City Central Booking. I am a trans woman. Upon arrival at Central Booking, I was met by two COs, male COs. where they proceeded to escort me back into a room. They asked me to take my clothes off so they could search me. And they both were joking and laughing at each other. After that, I went upstairs and I was assaulted by an inmate. And they transferred me to another section. On that section, Officer Warrior, he proceeded to sexually assault me every single day. I have PTSD from this. I was in solitary confinement. I'm sorry. And I'm going to tell you what solitary confinement looks like in central booking. You are in a cell 24 hours a day. Sometimes I wouldn't even be able to take a shower once a week. You're in a cell. You don't have no TV. In the wintertime, no heat. Summertime, no air conditioning. And I was there for 6 months. Right now, I'm in therapy every week because of this. And it's very inhumane. And it's the stress right now I have, it's unbearable. But I am here in favor of Bill SB 726. Thank you.
My name is Louisa Wayman. I'm here to testify in favor of SB 761. Thank you to Senator Smith for leading a healthy and productive discussion today. And thank you to everyone who has spoken today for sharing your voice. You have heard stats and figures about trans prisoners and the harms they have suffered behind bars. I'm here today to share with the committee a few stories of trans women who have suffered in Maryland's prisons. In 2015, Dayara Venabel was held in custody for 4 days on charges of 4th-degree burglary that were later dropped. When being processed into a men's jail, she was stripped naked and kept in a transparent glass cell for 45 minutes, while police and corrections officers leered at her, ridiculed her, and made inappropriate lewd remarks towards her. Her bra was confiscated, and she was forced to wear a sheer thermal shirt through which her breasts were visible. She was forced to go to her court hearing in that shirt. While in custody, she was repeatedly sexually harassed and demeaned by corrections staff, other inmates, and even the bail commissioner. In 2017, Portia Sims was placed into a male prison awaiting sentencing. There, corrections officer Olakenle Oyankami entered her cell and raped her. Sims is still in a male prison where, without the Trans Respect Agency and Dignity Act, she will likely remain for the next 12 years at daily risk of further sexual violence. Oyankami was sentenced to 90 days, of which he served 45. In 2019, Amber Cantor, held in a male prison notable for her advocacy on behalf of the rights of incarcerated trans people, was placed in an illegal chokehold and dropped to the hard floor. She suffered skull fractures and internal bleeding behind her right eye, among other injuries. None of these women were sentenced to sexual humiliation, rape, or grievous injury. To claim to have an equitable justice system, we must know that the sentence which is handed down by the court is the sentence which is served, and that is not the situation for transgender prisoners in Maryland today. Additionally, the 1994 Supreme Court case Farmer v. Brennan ruled that housing transgender women with men is a violation of the 8th Amendment's prohibition on cruel and unusual punishment, and the state of Maryland right now is in violation of that Supreme Court ruling.
Good afternoon, Mr. Chair and members of the committee. My name is Melissa Murphy, and I'm here on behalf of Women's Law Center of Maryland to request a favorable report on Senate Bill 761. For over 50 years, Women's Law Center has been committed to fighting for the economic security, the bodily autonomy, and the physical safety of women throughout the state. And to be very clear, when I say women, I include trans women, because trans women are women. And all women have continuously been forced to fight for equality in all areas of our lives. We are burdened by employment discrimination and a wage gap. We are disproportionately at risk for intimate partner violence and sexual assault. And we suffer from disparities in health outcomes from a medical system that minimizes and ignores women's health issues. But for our trans sisters, each one of these challenges is more difficult. This legislation would require that Maryland provide our incarcerated trans sisters with the dignity, respect, and safer living conditions that they deserve. For these reasons, Women's Law Center supports a favorable report on this bill. Thank you.
Good afternoon, Chair Smith, members of the committee. My name's Deborah Gardner. I'm the legal director of the Public Justice Center. And in that capacity, I'm one of the lawyers representing the plaintiff class in Duval versus Moore, the class action, the longstanding class action, not filed against Governor Moore, filed in 1968, concerning healthcare and mental health care in the Baltimore City Jail, which, as you know, is controlled and run by the Department of Public Safety and Correctional Services. The state is currently following an illegal policy that violates several federal laws and policies and national standards of carceral health care and even its own policies. At the jail in particular, they house transgender individuals in general population based on their anatomical gender, even if they have been engaged in medical transition and have sincerely held their gender identity and lived accordingly in the community for years. In August of 2022, our team encountered two transgender women suffering the consequences of this policy at the Baltimore City Jail, or the central booking unit where the jail is now essentially contained. One of them was required against her will to remain housed in the male general population despite a previous assault and injury by her cellmate. Excuse me. The other was involuntarily placed in the inpatient mental health unit because she had been threatened in male general population. This unit is beyond administrative segregation. It's beyond solitary confinement. It is a highly restrictive and highly intrusive environment. Basically total lockdown, deprived often even of clothing, leaving this woman, this transgender woman, constantly subject to the prying eyes of guards and medical staff, ostensibly for her protection. SB 761 comports with federal law the agency is currently ignoring by requiring individualized determination of housing placement based on safety and the individual's own perception of their safety, as well as the safety of others. And we urge a favorable report on SB 761. Thank you.
Excellent. Thank you very much for your testimony. Questions from the committee? All right. If not, thank you all very much. Thank you. So call one more time, Rosie Bean. All right. Is Melissa Rothstein and Aya Damons. You can go ahead. Sorry, go ahead.
Thank you, Chairman Smith, Vice Chair Walsh-Streicher, and members of the committee. I am OPD's Chief of External Affairs, and I previously worked for an organization focused on ending sexual violence in detention, where I helped develop the PREA standards and was certified as a PREA auditor. I'm pleased to testify in support of SB 761. I serve as OPD's media contact, and unlike other client-related inquiries, media calls about transgender clients inevitably concern an assault at a jail or prison that resulted in serious injury or death, followed by an article discussing how it could have been prevented. SB 761 is the legislator's opportunity to encourage those preventative efforts. The measures called for data collection, prohibition on discrimination, use of preferred pronouns, and consideration of gender identity in housing decisions are basic practices included in the PREA standards, and they will make individuals safer. Because corrections policies and practices currently focus on gender assigned at birth, individuals who are transgender, non-binary, or intersex lack protections to prevent their specific safety concerns. They also are not treated with the dignity and respect that sets a tone that their safety matters and that harassment and abuse will not be tolerated. Identifying as transgender is inherently dangerous in society generally and especially in the corrections setting. Suggesting that male identifying individuals will claim a female identity to prey on women prisoners defies this reality and ignores measures in the bill and current corrections practices that provide a check on dishonest information. In particular, the bill requires gender identity to be a sincerely held identity and creates a management or security concern exception. An individual whose gender identity at intake is inconsistent with prior assertions or behavior may not have their stated identity credited. Currently, gender identity is never taken into account, even in situations where it is unquestionably accurate and relevant. Safety determinations are very individual, and the constant risks faced in the community make transgender individuals uniquely capable of knowing where they will be safest. Some non-binary individuals will feel safer in a facility of their birth gender, while others know that incarceration based on genitalia will place them at constant risk for harassment, abuse, and possibly death. This is relevant information that corrections staff should gather and give appropriate deference. For these reasons, I hope that you will issue a favorable report on SB 761. Thank you.
Good evening, everyone. I'm Aya Damons. I am Baltimore Safe Haven's Executive Director and Founder. I wanted to tell you about my experiences in Baltimore City being incarcerated. I no longer knew who I was when I left from incarceration, afraid, scared, and could barely understand who I was when I left the cell. Yes, I needed to be treated fairly and equally behind those walls. I remember being the laughingstock for everyone, from COs to inmates. I could barely obtain my food during meal times. I was completely numb. I was sent to the SHU. I'm so sorry, y'all. This is reliving trauma for me. I was sent to the SHU and I was disorientated, stripped to basic accesses of services from feminine products to life itself. I was in a cage inside of a cage and labeled as a threat to security because I looked like a woman. I was shipped and reshipped and sent to places I have never been in my life, afraid of my own shadow when I was released from 23-1. I still settle in my mind that I'm at home when I open my eyes because I'm so afraid that someone might come through those doors and get me. I founded a program called Baltimore Safe Haven, led by a lived experience executive director. I'm the only direct services provider in Baltimore City, the only housing provider in Baltimore City for LGBTQ folks. I stand behind this as my carbon footprint does not have to go through this trauma anymore. As I'm afraid as I talk to you all right now, we need this. The ball is in your court. As my fellow friends and siblings stand behind me and they tell you that united we stand, please hear our cry. We stand with this bill. If you've not heard anything else from me, please, I'm afraid when I wake up in the morning because this trauma still haunts me today. Support this bill.
All right, thank you very much for the testimony. Questions from the committee? All right, thank you very much. Thank you. All right, looks like we'll switch to the virtual participants who are in favor, and we'll start off with Nicole Hansen-Mundell. You're up.
Good afternoon, Mr. Chair, and to all of the resilient advocates sitting in this room today supporting SB 761. My name is Nicole Hansen-Mundell. For the record, out for justice in full support of SB 761. In 1994, the U.S. Supreme Court ruled that failing to protect transgender people in custody is unconstitutional and found deliberately failing to protect incarcerated trans people from abuse or violence behind bars qualifies for cruel and unusual punishment. And nearly 30 years later, after this landmark Supreme Court decision, many individuals that identify as transgender are still under imminent danger while incarcerated. As Ms. Aya talked about, far too many are raped, sexually assaulted by other prisoners, and abused by corrections officers for fear of retribution, including being thrown into solitary confinement. Despite the robust evidence that you all have that trans women are at significantly higher risk of abuse and assault than the general prison population, the vast majority of incarcerated trans people in America are still housed in facilities based on the sex they were assigned at birth. OFJ members have shared the inhumane and disgraceful treatment of trans women in custody. Trans people in custody, period, often starts immediately upon the intake process. Our folks are over 9 times more likely than the prison average to be assaulted or abused by fellow incarcerated people, and over 5 times more likely to be assaulted or abused by facility staff, according to the national survey conducted, as you know, by the National Center for Transgender Equity. Opponents of housing people in custody according to the gender identity argue that men could falsely claim to be transgender, so they are housed with women that can then assault. If I can finish my statement, Mr. Chair. There is no evidence to support that this happens. While there is overwhelming evidence that trans women and men in men's prisons are being sexually assaulted at higher rates than the general incarceration. In closing, PREA standards state that the prison staff must consider housing assignments on a case-by-case basis and not simply on the basis of a person's genital status. Additionally, the standards state serious consideration should be given to an incarcerated person's own views regarding his or her own safety. In practice, these standards are not protecting our people. And we please ask you, Mr. Chair.
Thank you very much.
No matter how controversial this issue is, please, let's get this bill out of this committee and to a vote. Thank you, Mr. Chair.
Thank you very much. All right. Elise, you're up.
Good afternoon, all. My name is Elise Desiderio with the Office of the Public Defender, urging a favorable report. It is dangerous to be trans anywhere, and it's especially dangerous to be trans in prison. Trans people are 5 to 10 times more likely than cisgender people to be physically or sexually assaulted while incarcerated. When they are, the so-called solution is too often prolonged solitary confinement, as you've heard from people who've lived it. Currently, our state law doesn't provide specific protections for trans or gender expansive people who are incarcerated, and current policy is damaging and not PREA compliant. This bill begins to address those discriminatory practices. Other panelists have already detailed what this bill does, so I'd like to close with a little bit about my very first client. Let's call her Lisa. I was a student attorney at Maryland Law in a clinic representing people incarcerated pre-trial. Lisa was a trans woman housed with men in Baltimore City Central Booking. When I visited her, I witnessed corrections officers routinely misgendering her. And they attempted to joke with me about her gender identity, as if I would laugh with them, as if others before me had laughed with them. Lisa was being held on suspicion of committing nonviolent offenses. Through the clinic, I was able to get her released on her own recognizance and back at home with the woman she called her mother, an older trans woman who was involved at every step of my representation. If I recall correctly, all charges against her were ultimately dropped. I'll never forget her. Despite the conditions of her confinement, Lisa was kind and open with me. Greeting her as she left pretrial confinement was the first highlight of my career as a defense lawyer, and one that I will always treasure. I told her so as I hugged her goodbye. This legislation will help real people in real trouble. We at OPD urge a favorable report. Thank you.
Thank you so much. Questions for either of these witnesses? All right, seeing none, we'll go to an informational testimony. Jeremy Browning. Mr. Browning, you are up for informational purposes.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Jeremy Browning, and I use he, him pronouns, and I am the Administrative Director of the Maryland Commission on LGBTQ Affairs. Thank you for the opportunity to provide informational testimony today on behalf of the Commission. I would like to thank the members of this committee and the General Assembly for their work on behalf of our LGBTQIA+ communities and their families. The Maryland Commission on LGBTQ Affairs was created by the 2021 Maryland General Assembly to assess challenges facing our community, collect data across the agencies, study and establish best practices for inclusion, and offer testimony on issues concerning our LGBTQIA+ communities. Senate Bill 761 is a top priority for the Commission and represents a critical step towards ensuring that our transgender, non-binary, and intersex community members are treated with dignity and respect while in custody of the state. The bill's requirement for the Commissioner of Correction report to include information regarding the gender identities of incarcerated individuals and their housing status will provide important insights into their experiences while in custody of the state. Additionally, this bill will ensure transgender, non-binary, and intersex individuals are not subjected to harmful practices such as housing in restrictive or single-cell housing simply because of their gender identity. With this information, Chair and members of the committee, I conclude my testimony. Thank you.
Thank you for that informational testimony. Questions for Ms. Browning? Mr. Browning, thank you very much for your testimony. We'll now move to the opponents of the bill. Brandon Foster, Ella Ennis, please come on up.
Good afternoon, Mr. Chairman and members of the committee. I'm Ella Ennis, and I'm here to represent the 1,426 members of the Maryland Federation of Republican Women. We are opposed to Senate Bill 761 to allow biological male prisoners to identifying as female to be housed in the women's correctional facility in a cell with biological women. There's been much said about the need to have safety for transgender women inmates, but biological women inmates also deserve to be safe and to be respected. There is no safety for biological women in a cell with a male choosing to be identified as female. Showers and toilets are not private. Any inmate is vulnerable in these circumstances, and adding additional danger by housing biological males in a women's facility is unacceptable and unsafe. Treating transgender, non-binary, or intersex individuals with respect does not require to house them in the same women's facility. Separate housing wings or facilities specifically for transgender or non-binary or intersex inmates is a safe alternative for everyone. The Maryland Women's Correctional Facility has a capacity for 850 inmates. In October 2020, it housed 517. It has the capacity and the layout to be able to be safe for all. There is a distinct movement arising to erase the unique characteristics and biology of women and to remove all separate and safe places for women. Senate Bill 761 would do just that. It wipes out any safety for biological women inmates in the correctional facilities in Maryland. And I ask you, please, to give an unfavorable report and to honor and respect all inmates, all people in a correctional facility, but to see that women inmates are not put in danger for unreasonable reasons, and to give a separate facilities to each type of inmate. Thank you.
Good afternoon, Mr. Chair, members of the committee. I'm Director Brandon Foster, Director of Charles County Detention Center. Correctional facilities in Maryland have a constitutional obligation to ensure the equitable treatment of all inmates and to provide for their safety and health. Our policies and procedures reflect those obligations, and we strive to accomplish these goals. The limits and requirements of this bill are a form of micromanagement that would make it very difficult to meet the goal of safe and effective case management. Correctional managers are very aware of transgender issues related to incarceration. There is generally more awareness of transgender issues today than there ever has been. For correctional managers, these issues are much more complex than just how one identifies or their preferred honorifics or pronouns. Our policies reflect the recent decision by the Fourth Federal Circuit Court, whereby the decision for placement of an inmate cannot solely be based on a person's genitalia. Case management teams must objectively consider several factors when classifying and placing inmates. And inmate safety is priority in making these critical decisions. A good classification policy considers safety, health, vulnerability, current criminal charges, past criminal behavioral history, gender identity, and many other factors. Unfortunately, we could not meet our constitutional obligations if these decisions were left almost entirely to an inmate's preference. We do agree on parts of the bill in regard to having consistent definition of gender identity. And we also agree that upon the requirements of non-discriminatory policies, which I can assure you that jails and prisons in Maryland already have. I believe it's too soon to pass legislation on this issue when we give it real world consideration. There is considerable ongoing litigation related to these issues. Passing this bill would most certainly lead to an explosion of litigation in Maryland. Some of the legal questions that remain are, is it a constitutional violation to place an inmate not according to preference, but according to several other legitimate risk factors? Do officers have a legitimate harassment complaint when required to search someone of the opposite biological sex? Is it a constitutional violation under the First Amendment to compel speech by officers to the preferred pronouns and honorifics of an inmate? I expect that the courts and possibly the U.S. Supreme Court may issue future rulings on these issues. In the meantime, it is unwise to pass legislation that would likely lead to a flood of litigation and would cost the state and local governments in Maryland millions. I urge an unfavorable report on this bill. Thank you.
Thank you very much. This question is for the sheriff. I'm looking at your testimony, but I'm curious what Fourth Federal Circuit Court decision were you referencing?
Williams v. Kincaid. Kincaid would be the sheriff of Fairfax County. It was last year.
Williams v. Kincaid.
Williams v. Kincaid.
Thank you.
Additional questions from the committee? All right, seeing none, thank you both very much. Thank you. All right, I believe that's it. Is that it? Oh, all right. Well, for this bill, I said that concludes the hearing for Senate Bill 761. We are now going to move on to our final bill of the day with Senator Benson, and we will await Senator Benson's arrival. Is there a lead witness as a proponent to this bill, to 771? Sure.
Is there a sponsor panel or just?
It's a sponsor panel, I guess. Are you sure? What is your name? Okay. Um. How about, can you both come on up then? And this is unorthodox, but we do need to get the show on the road. I know you all have waited all day. So one of you'd like to start?
I had a very specific technical argument. I was going to need some resetting my.
Sure. Thank you, everybody. I know I did call Senator Benson's office. Hopefully she can come down soon, but my name is Magdalena Chungus. Thank you so much for having a hearing for this bill and giving impacted family members the ability to testify. My loved one, John, is incarcerated here in Maryland. At the age of 19, he was sentenced to life in prison. And so for him, there's been this transition really from hopelessness to finding meaning in the work he's able to do to support other incarcerated men. And that looks like leading AA and NA groups, being an usher in church. He's finally had the opportunity to take college courses and pursue getting a degree while incarcerated. But we know that what this bill is not a ticket home for anybody, but it does give an opportunity. And it gives an opportunity for men and women and other incarcerated people after 20 years to ask a judge to look at the growth that they have accomplished over those 20 years and to see if that is enough to merit a change in their sentence. I want to thank Senators Smith, Waldstreicher, and West who have previously sponsored this bill in other session. I hope you are still in support. And I hope this is the year that we can get a vote on the bill, because I know there are other incarcerated people who really have been waiting decades for this opportunity to get to show what their growth has been while incarcerated. Thank you so much.
Hi, I am Ann Bocchini Kirsch. I'm Director of Advocacy for Prepare. And this bill is close to me because I tend to meet these cases at the point when this bill would kick in. This is something that would give someone a second look after 20 years. And if you can imagine a sentencing judge trying to see what somebody is like after 20 years, you might imagine looking at a class of graduating high school seniors and trying to figure out what they're going to be doing when they're 40. It's not possible. A second look is a second look. It is not an automatic release from prison. And in fact, nobody would ever have to be released under this piece of legislation if nobody was found to be worthy of being released under this legislation. But the fact is that the way our current system is, for most people, because over 95% of people take a plea, they have two legal options. One is a modification, which expires after 5 years. And the second would be a post-conviction, which expires after 10 years. And in many cases where people have long sentences, and maybe they did actually commit their crime, but they did it when they were young, or they did it as a result of other circumstances, they may not have enough time in that 5 years to show rehabilitation. They may not be ready to come home after 5 years. They may not be ready to come home after 10. This allows for people who have done spectacular work, who I meet frequently in my line of work, who can really become a benefit to the community on this side. This allows them to, after 20 years of incarceration, say, this is what I've done. Yes, when I was a high school senior, when I was that kid, things looked really bad, but things are really great today. We are currently paying to keep the solution away from the problem. These people could be out in our community helping to quell the violence and solve the problem. And that is why I urge a favorable report on SB 771. Thank you.
All right, Senator Benson is here. We're gonna have Senator come in. Welcome, Senator.
Good afternoon. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. We're just finishing a bill that, just as an aside, we just got finished talking about Senate Bill 959. And I did tell the people who were in the room that on behalf of all of us down here, we are very unhappy as we think about this issue with higher education. It was quite emotional. But nevertheless, good afternoon once again. I'm here to present Senate Bill 771, the Maryland Second Look Act. With 2 million people confined in the United States correctional facilities, the United States currently leads the world in the incarceration of its citizens. The Maryland Second Look Act will aid prison reform by providing deserving individuals a chance to be high-functioning members of society. The bill will allow for people in the prison system to be able to modify their sentence and be given a second chance, a chance that no one else would be given. There's a large percentage of teens who are incarcerated to spend the rest of their lives in jail. The prefrontal cortex is the part of the brain whose sole function is to control impulses and make good decisions, but it's not fully developed until the age of 25. Additionally, during the past 40 years, jail populations have grown by 500%. The majority of this increase is explained by changes in laws and practices utilized for sentencing, not changes in crime rates. The Maryland Second Look Act ensures the fairness of the imprisonment system in the state of Maryland. The intent of this legislation is to make it possible for someone who is currently serving a sentence to request a court modification or reduce their sentence under certain circumstances. For the petitioner to have the choice to seek appeal after their conviction, they must first have completed both accompanying impediments. The first part of the impediment is to have served 20 years of the sentence without the utilization of diminution credits. And the second part is to have the equivalent of a 25-year sentence with the utilization of diminution credits. Under this measure, the offender's appeal of a sentence change or reduction will be allowed to be opposed by the victim of the crime or a representative of the victim of the crime. In conclusion, this bill will guarantee that we maintain fair practices and just sentencing in our court system. I might want to add that we did look at the data, and the great state of Maryland is number 2 in the country when it comes to the incarceration of people in our prison system. We are number 2 in the nation. And over 80% of those persons incarcerated are persons who look like me. I would ask that you all take careful consideration to the passage of this bill, Senate Bill 771. Thank you.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. John Giannetti for the Maryland Criminal Defense Attorneys Association. Thank you all for you do some heavy lifting in this committee. I admire what you do. I'd like to you've heard the senator now, and this is a tough time of year to bring up a new philosophy like this. This is a very important bill. I heard that the chairman said there's over 20 people signed up for it. I mean, this has been one of our priority bills for several years. Thank the senator for putting it in. It's difficult as a non-member of a committee to put in a bill that's this weighty. But let me just say this, when I sat in that seat right there where Senator James sits, you think you make some regrets, you make some right votes, you make some wrong votes. The thing is, the system, at least I had the opportunity several times to be able to change my vote. I learned, I grew, we all grew. I think as a state, we make mistakes as a judicial system, as our jailing system, as our court system, we make mistakes. Well, how do we fix those? Well, we can make some sweeping changes. The governor did the JRA, that made a lot of changes, right? Some things, some punishments were erased, some punishments now you can expunge them. But we can't do the fine points. We can do the sweeping changes. So how do you deal with these individuals who things have changed in the last 20 years, last 40 years? These individuals, we took away the original right to have a reconsideration of your sentence. I remember it was in the House when it happened. All right, we made a mistake. Now there's no way people sitting there without any way to reconsider your sentence. This bill will simply give individuals an opportunity after 20 years or 25 years with diminution credits to have an opportunity for a judge to make a case to them. Maybe you should consider, maybe the state has changed, maybe the view of crimes have changed. Just give me an opportunity. It doesn't release anyone. It gives everyone an opportunity to go to our judge. Nobody better in our system to determine whether or not we made a mistake. I ask you for your support for this bill. Thank you.
Good afternoon, everyone. I'm Shekina Braveheart, Advocacy Associate with the Justice Policy Institute. When there is harm, there needs to be repair. Maryland's parole system does not work as a decarceration mechanism it should. The 2016 Justice Reinvestment Coordinating Council revealed that only 37% of offenders released in Maryland are released through parole. And of that 37%, individuals served an average of 9 months past their parole eligibility date. Despite rehabilitative success and program completions, parole eligible individuals are subjected to perpetual rehearings. That is a broken system. We need remedies. As many people already mentioned, Second Look does not guarantee anyone will get out early. Instead, it just gives incarcerated people an opportunity to show that the original sentence no longer fits. Judges get to consider individuals' post-conviction progress before determining that a sentence or reduction or release poses no risk to public safety. Excuse me. The strongest reasons to support Second Look point to the low risk of reoffending. Ex-offenders who've been released through the Juvenile Restoration Act, JRA, are now contributing, thriving members of this community. To date, no one has reoffended, 0 recidivism. The Ungers, 10 years after release, have only a 3% recidivism rate. More Ungers have died than reoffended. According to a 2022 poll conducted by the conservative political and public affairs research firm, Public Opinion Strategies, American voters supported Second Look laws by a margin of 2-1. And by more than 2-1, voters believe people should be considered for early release if they are unlikely to commit future crimes. This indicates a prioritization of public safety over prolonged punishment. Second Look is an outlier in the sense that it is not what voters mean when they say get tough on crime. It's clear our communities desperately need, want, and deserve safety. We do not want to compromise safety. However, it's evident that reforms around release mechanisms need to happen. It's long overdue. JPI urges this committee to issue a favorable report on this bill. Thank you so much.
Thank you very much. All right, questions from the committee? Senator McKay.
John, I think you probably can answer this question more.
Yeah.
So, I don't get it.
Right.
All right. We have a parole system. It's every 3 years, sometimes depending on where they are and how they answer the questions. They have a chance to show their progress. Maybe it goes down to 2 years, maybe it goes to 1 year to hear a hearing again. I don't understand. The system seems to be here. There's been people who have talked to that it's broken,
right?
But I don't mean understand more of a lay person's why.
Senator, it's still broken. It's I don't think we'll ever have a perfect system, right? Try to get more perfect. There are plenty of sentences that are not parole eligible.
Okay.
The person has no chance. Back in the day, there used to be a motion that every defense attorney would file when your client was sentenced to jail. file for reconsideration. It has to be filed within 90 days. Bill came through that says, well, wait a minute. We should really put a limit on how long these bills could be, because that motion, as long as it wasn't ruled on by the judge, could be heard 10 years later, 20 years later, 30 years later. So what that's ridiculous, said the person who is sponsor of the bill, who is now the Attorney General of this state. And a lot of us agreed, and they limited it to 5 years. After that 5 years, that motion is no longer eligible. There are ways to file motions, something called quorum nobis, that you can say, hey, I deserve an extra shot. They're few and far between. This just allows a person to say after 20 years or 25 years, if you let's say have a 50-year sentence and you get diminution credits and it brings you down to 25 years, you get to file to the court. And if you're eligible, you just get a moment in court. And the bill makes a lot of sense because it makes sure that the victims have an absolute right to be there present. And listen, I know that, my good friends on the other side of this issue, the prosecutors, you're going to hear, we call this the second look legislation. They're going to say, well, it's not second, it's third, fourth, fifth, because if you're denied a right to have your sentence reheard, you get another chance in 5 years. So after 20 years, 25 years, 30 years, to me, and the victims are allowed to come in at each of those times. I think in our system, I want to be very careful what I'm saying here. I'm not equating the people who committed the crime with the victims of the crime, but in a way, the members of my association, the criminal defense attorneys, we see some of the injustices in this court have created a whole other group of victims. These people who are in jail, maybe unjustly, because things have changed. Society's changed and they have no way to get to the court. So this is just an opportunity to get to the court, and we can't make a law that's going to address everybody's concerns. That's why you have each individual go in front of a judge. Who do we trust better than a judge to see if that person deserves to get out? They fix those facts. They talk to those victims, and maybe that person deserves another chance, but maybe not. Maybe that person should go back in and wait another 5 years before they have another chance. That's all this is saying, is just have an opportunity to get to a judge by right in the law.
Okay, thank you, sir.
Sure.
Additional questions? All right, thank you all very much. All right, did we hear from Monica Cooper? What about, is that it for the favorables? Carol Puccini? Is Carol here? Are you all coming up? All right.
Okay. Thank you. Good afternoon. My name is Carol Bocchini. My daughter, Ann Bocchini-Kirsch, and I recently hand-delivered to your office a packet with a description of the Who I Am Today project, with the statements of 5 of the hundreds of individuals serving long sentences who have completely rehabilitated themselves and helped others to do the same. They would not only be valuable members of society, but have much to offer in helping others to avoid making the same mistakes that they made in their youth. Given the thousands of individuals with long sentences in prison, especially among the men, we expected to get hundreds of responses, which we did, similar to the ones in your packet. What I have here to show you today is something we didn't expect. It is a collective portfolio of 40 trained peer recovery specialists with a long history of leading others in the right direction, and includes their stories of how they transformed themselves into who they are today. It was put together by Kian Eason, one of these specialists, who has spent 22 years behind bars. I was doing my editorial work at home the day my daughter picked it up from the post office. I was just going to take a quick look at it before getting back to work. But once I started reading it, I couldn't put it down. It literally brought me to tears. The conditions of their childhood, their previously undiagnosed mental illnesses, their unaddressed learning disabilities, their lack of good role models, their violent environment, the remorse turned into a passion to not only change themselves, but to show other men from similar circumstances how to change as well.
I couldn't help thinking these are amazing, caring human beings. What could they have accomplished if they had been born into different circumstances? What could they accomplish now if they were given the opportunity to use their skills to mentor youth on the outside and help them to make better life choices? There are jobs waiting for these men and women on the outside. Instead of taxpayers paying to keep them in prison, they could be earning a living while using their professional training and lived experience to mentor at-risk youth, thereby helping to solve the juvenile crime problem in our state. Such men and women need a second look. Thank you.
Thank you very much. All right, questions from the committee? Seeing none, thank you for being with us. All right, now we'll switch to our virtual participants, and we're going to start off with Mr. Gordon Pack. You're up. Welcome.
Good afternoon. Yes, thank you for the opportunity. My name is Gordon Pack. I'm a parole advocate and a beneficiary of the Juvenile Restoration Act. If not for this particular act, I would still be in prison today. As a 15-year-old in 1979, I was convicted of committing violent offenses, and I was given a life sentence. After 42 years of incarceration, I had no idea when, if ever, I would be released and what was expected of me to obtain release. I actually became eligible for parole in 1992. We're talking 32 years later, I'm still in the same situation. The problem, quite simply, is that there's no presumption that anybody will receive parole upon reaching eligibility. The Parole Commission has a very difficult job, something I would not want to do. But what happens is that they have the authority to render any decision they want without explanation. As a result of that, many people who have demonstrated maturity and rehabilitation, who are no longer a threat to public safety, remain in prison simply because of the nature of their offenses, which the sentencing court had considered before imposing the sentence. The sentencing court also anticipated when that person would be eligible for parole. However, just because somebody reaches parole, it doesn't mean they receive it. So I would ask that this committee supports and rule favorably in support of Bill 771. Thank you for your time.
All right, thank you very much, Mr. Pack. Next, we'll hear from the Maryland Justice Project. Is Monica Cooper?
Yes, my apologies.
Hey, Monica, how are you?
How are you, Chairman? My name is Monica Cooper. I am the Executive Director of the Maryland Justice Project, and I ask for a favorable vote on Senate Bill 771. I can tell you from experience that after years of confinement, most individuals are not the same person they were when they entered the DOC. When a human being who was caught up in addiction, drug dealing, and a street life have years and decades to think, pray, grow, and ask for forgiveness, they are not the same individuals that entered the prison system. Many times, staff, correctional officials, loved ones see the growth. However, sentencing judges don't get the same opportunity because the ability to petition the court has been exhausted. The many programs, certificates, and accomplishments the judge never get to see. The judge never get to see the reduction in status that person was able to achieve because they displayed exemplary behavior. These individuals have spent years of incarceration, and by the time they try and petition the court, by the time they have obtained education, by the time they have mentored people, by the time the psychiatrists, the sergeants, the majors, by the time these people are writing all these letters saying that this person deserves a second chance, they unfortunately are not able to show the court. This is what the correctional staff has said. This is what the psychiatrist has said. This is what my religious leaders have said. And they usually end up with a packet like this to demonstrate and show that I have changed. So can you please look at my situation? But because the time is exhausted, the judge never get to see that. The judge themselves recognize the change in those human beings if they get the chance. Give the judges a chance. Thank you.
All right, thank you very much, Monica. All right, next we'll go with Brian Sixenti. You're up.
Thank you, and good afternoon. The Office of the Public Defender supports this bill with a few friendly amendments outlined in our written testimony. This bill really builds on the success of the 2021 Juvenile Restoration Act, which allows people who have served at least 20 years for an offense that occurred when they were a minor to file a motion for reduction of sentence. So far, 31 rehabilitated, non-dangerous people have been released under the Juvenile Restoration Act. None have recidivated. To the contrary, they're attending school, working, volunteering, and making positive contributions to the community. The state saves a lot of money as a result of such releases, and it can, if it wishes, and we would certainly encourage this, redirect those resources toward programs that actually protect public safety or meaningfully assist victims beyond simply punishing the offender. When a judge punishes someone, they need to make an educated prediction about whether that person will continue to pose a danger in the future. When we go into court on these motions, there's a 20+ year record of behavior for the court to look back on and assess whether the person can be safely released. Put simply, Senate Bill 771 provides an effective way to reduce unnecessary incarceration by identifying individuals who can be safely released from prison and releasing them in accordance with a release plan designed to maximize their chances of success. I'd like to respond briefly to Senator McKay's excellent question. Why isn't parole enough? Well, I think it boils down to this. There's no right to counsel at parole. Counsel in these Juvenile Restoration Act hearings, we gather mitigation. We can retain psychologists as experts in appropriate cases. We can develop release plans and put a lot of effort into that. We can attend hearings and have back and forth with the judge. In parole hearings, you don't get that. Even if a person can hire counsel, the lawyer can't go to the hearing and represent the person. They can talk to a commissioner for up to 30 minutes beforehand, but there's no guarantee it's going to be one of the commissioners that actually hears the case. So that makes a huge difference and is instrumental to the success of these second look motions. So we'd urge a favorable report. Thank you.
Excellent. Thank you very much. Questions from the committee? Seeing none, actually, we have one question from Senator West.
Yeah, thank you, Mr. Chair. Let me address the public defender, the last speaker. I was the author of the Juvenile Reform Act that we passed two years ago, as I recall. And the deal there was we were dealing with juveniles, people who were under the age of 18, and their minds were 7 years away, their brains were 7 years away from maturing, and they were teenagers. Everybody changes after they cease being a teenager, and we had very rigorous standards, two standards that would have to be achieved in order to get out. First, that the court would have to find that the incarcerated individual is no longer a threat to society. And secondly, that the interests of justice would be served by eliminating the rest of the sentence. So this bill, as I read it, it waters down those standards for juveniles, and then it applies basically the watered down standard to someone who committed a crime not when he was a teenager and irresponsible, but when he's much older and at an age that we should expect him to be acting responsibly at the time he committed the crime. So could you, with that as a predicate, can you explain why you believe that the Juvenile Restoration Act should be used as the template for this?
Well, thank you. I appreciate the question, Senator West. So a few things. First, as you point out, 18 isn't a magic number. It's not like we hit our 18th birthday and suddenly everything changes. The brain continues to mature until about the mid-20s. And so one of the benefits of this is that, those folks who functionally are still thinking and acting like juveniles would have an opportunity to file a motion. But beyond that, I think There are a few things. One is you mentioned the standards, the interests of justice and dangerous, that the person not be a danger. I believe that the non-dangerousness requirement is already baked into 771, but I certainly, we would not oppose an interest of justice prong as well in there. I think that would be fine. But additionally, I think the reality is that people through their life continue to have the capacity to change and to grow. And that, we also know that people tend to desist from committing crime as they get older. So additional benefits of this bill would be that the court could take those factors into consideration. And, the person who commits a crime at age 30 may not have some of the mitigating circumstances that a person at age 20 might. But nonetheless, if that person can demonstrate that they have really changed, have been rehabilitated, that it would be in the interest of justice to reconsider their sentence, we think that's an appropriate thing.
But for the older people, over 18, who commit a crime over 18, where they're not a juvenile, not a teenager any longer, that's why we have the parole commission, I thought, right?
Well, certainly we have the parole commission for people under and over 18. I think one of the real problems of relying just on the parole commission is what I just said, that there are additional procedural protections when you go into court and opportunities that frankly allow us to make a fuller presentation to a judge than we'd ever have an opportunity to make to the parole commission. And that fuller presentation, I would submit, leads to better, more reliable, more accurate results.
Let me just, one final thing, a suggestion that I think I could support a provision that would, when someone approaches the parole commission, accord to that person the opportunity to be represented by counsel. That's something that I think makes some sense, rather than having to go it on your own. And if I could suggest that maybe next year you come back with a bill that would do that, and that would give some tangible benefits to someone who gets convicted of a crime committed after the person reached his age of majority. And with that, I'll be quiet. Thanks.
Thank you, Senator.
All right, seeing no further questions, thank you all very much. So that'll conclude the testimony for the proponents of the bill. We'll now switch to our opposition panel, and we'll hear from Mr. Schellenberger, Mr. Katzev. Oh, actually, I'm sorry, my apologies. Is Judge Karuman, is Phil Karuman there? Okay, got it. So now we are in the opposition panel. William Katzev, Mr. Schellenberger, is Karen Mitchell, Steve Kroll. I think that's it. Go ahead.
Great. So Senator West, great idea. Mr. Katzev and I said we would not oppose that bill next year for the parole commission. Good idea. So you're the victim of a violent crime. About 2 weeks after you've been carjacked at gunpoint, the police call you up and they say they made an arrest. About 1.5 years later, you've been waiting for trial, and you finally have a trial that lasts nearly a week. So then when the jury comes back 7, 8 hours later, you hear the words you've always wanted to hear, and that is the words guilty. And you think it's over. But it's not. After you hear the words guilty, there's a motion for new trial, motion to modify or reduce sentence, which can be held for 5 years. If that motion for modification is based on an illegal sentence, fraud, mistake, or irregularity, no time limit. Another one can be filed. A 3-judge panel to reduce or modify the sentence. Appeal to the Court of Appeals of Maryland. Appeal to the Supreme Court of Maryland. Post-conviction. Many times you get more than one. Post-conviction hearing. Writ of Corbin Novus. Writ of habeas corpus. Writ of actual innocence. Motion to vacate judgment. You all just passed that 2 years ago. Motion, post-conviction motion for DNA testing and a parole system that you recently took the governor out of. My question is, when does it end for the victim? The case I talked to you yesterday the Caprio case. They will have to go to 4 hearings after 20 years, 25 years, 30 years, 35 years, 4 hearings every year. It's just not right. It's just not right to subject victims to this many instances when there is a system that was put in place to decide when criminal defendants get out of jail, and it's the parole system. A parole system that I would suggest everyone says isn't working because they're not getting their way. Well, maybe there's a reason for that. Maybe it's because they committed murder. Maybe it's because Mr. Pack, who just testified, was convicted of 2 first-degree rapes. Remember, the judge who sentences the defendant in these cases knows more about the case than anybody else will ever know. And JRA, we did have dozens of hearings of juveniles, and you heard that 31 were let out. Well, it just means that the people who are there are supposed to be there, because the thing no one has said yet is that they got the appropriate sentence and they are being punished appropriately. I'm against Senate Bill 7071. I urge an unfavorable report. Thank you.
Good afternoon. My name is Karen Piper Mitchell. I'm the Deputy State's Attorney for Charles County, and we oppose on behalf of the Maryland State's Attorneys Association, following up colleague, the other things that exist is a Maryland Health General articles where people can also look to ways in which they can have their sentence reduced. When you talk about the needs of the victims, again, yes, we have to have them there. Yes, we get in touch with them, but you're talking about after a sentencing that happens in the circuit court, we have to go back to our victims and tell them, hey, not only are you waiting for the appellate process, then we have this motion for reconsideration of sentence. And then in 20 and 25 years, you have to keep coming back. That's if the judge doesn't make a decision. Once you have a difference in those people who are serving in the office, once you have a difference in those who are serving on the bench, who have a disconnection from the case. Additionally, you have some of these cases, I think we need to be clear on that. This body, the General Assembly has looked at making some changes in certain kinds of cases. When you look at the Justice Reinvestment Act of 2016, you dealt with the mandatory sentence on drug cases. So we're not talking about drug cases. When you talk about the Juvenile Justice Reform of 2022, we're not just talking about juveniles. And a lot of the probe was about the juveniles. We're talking about those individuals that have committed murders. We have a sexual abuse, child abuse person who 42 victims in our school system. That means that at the 25-year mark, or maybe the 20, more like 25-year mark, I have to go back, or whoever is in that place has to go back and tell these victims, you get to come back every 5 years to say why it is when you were sexually abused as a child. We have a victim who plotted to murder the child and the mother of the case after he sexually abused her, the little girl. We have to go back and say this provision still lasts. It is important that we look to the victims were chosen by the defendant. That is why they're in this situation. So we ask that you vote against this bill. Thank you.
Mr. Chairman, members of the committee, my name is William Katzoff. I'm an Assistant State's Attorney for Anne Arundel County. I too am here to speak in opposition to Senate Bill 771. When a defendant is convicted, that defendant is subsequently sentenced by the sentencing judge. Okay, if a person is dissatisfied with the sentence, there are a number of options. There's the appeal route, and there's also the route of attacking it by, or at least asking for a reconsideration of sentence or a 3-judge panel. Now, when a judge sentences somebody, that judge sentences that person based on the information that he or she has at that particular time. Now, that person is then sent to the Division of Corrections for a fairly lengthy period of commitment. Now, obviously, you've just heard about all the post-trial remedies that person could have. However, it is then the responsibility of the Parole Commission to determine how that person has progressed while in the correctional system. It is not the sentencing judge. The sentencing judge has the opportunity to reconsider a sentence in the event that perhaps passions were running high and maybe in retrospect, it was not the appropriate sentence. But once the sentence is being served and those options are no longer available, it's up to the corrections department to determine how that person monitors that person's progression and whether that person should be granted parole. This bill envisions taking the responsibility of the parole commission and then placing it in the hands of a single sentencing judge. I don't think there's anything that should allow a sentencing judge many years down the road from substituting his or her judgment from that of the parole commission. It's the parole commission that should take responsibility for determining when someone should be released after they have spent time in the correction system. One additional factor is that we were talking about the number of appeals. This bill would allow for somebody who is denied the relief that's requested to then take application to leave. So there's an additional appeal that's available in this, even in this bill. So with that in mind, Your Honor, Mr. Chairman, members of the committee, I would ask that the committee give the bill an unfavorable report.
Second time today.
Mr. Chairman, members of the committee, good evening. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, the Executive Director of the Maryland State's Attorneys Association. And Senator Sidner, I will not say how long I've been practicing law, just to tell you. And I'm here asking for an unfavorable report as to Senate Bill 771. I will say this, when someone goes and they serve the time of 25 years, they've committed a serious offense, a heinous act. And for the most part, victims do not get a second look. Victims do not get a second chance. And who do they appear from 25 years later? From my experience, most of those judges who heard their case originally are retired or gone from the bench at that point in time. They get a new judge who has absolutely no clue about their case at all, and they have no idea what's going on. The parole commission has a steady way of seeing people on a regular basis, and there's notes and there's parole commissioners who see them, like I mentioned before, on a regular basis. That judge sitting 25 years later has no idea what that case is about. That judge may be a domestic judge, maybe a judge not familiar with criminal law, and they're about to hear a case that they're unfamiliar with. It's not fair to the victims. It's not fair to the system. And again, it's not fair to victims who, again, do not get a second look. And for the reasons mentioned by Ms. Karen Piper Mitchell, by Mr. Schellenberger and Mr. Katz, if we'd asked for unfavorable reports to Senate Bill 771, and we're happy to answer any questions. Thank you.
All right, questions from the committee? All right, seeing none, thank you all very much. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 771 and our hearings for the day. We are going to take a 10-minute break, and then we're going to just power through and do some voting. We're not going to be here terribly late because we don't have hearings tomorrow. We probably have a double session tomorrow. So in between, we'll vote. So we'll vote on Thursdays. We're going to vote on Friday. We're going to vote Wednesday, Thursday, Friday. So so we're not going to stay super late tonight. Yeah. All right. So we have to reboot the system. We'll be right back online in about 10 minutes.